So it will be page 11, paragraph 26. So the old one, the last sentence, the second last sentence, reads the Operations Manual version 2.0 was signed by me as head of an operation and by the ID on 16 October 24, and it was shared with employee at IDAC. It is in substance and the manner of its adoption a policy of the unit. The new one inserts the date on which it was shared with all of the, and so it says, and it was shared with every employee of IDAC on the 22nd of October 2024 at 11:31. So that's the inclusion.
Yes, we are ready.
Thank you. And so whether or not you look at the signed or unsigned, that is for this morning, Chair, I can't guarantee about this after, but certainly this morning using one file, and that's the statement file with the, I have one file, but I'm advised you have two files, one containing the statement and the other annexes. Mr. Sesoko, you also would have two files in front of you, one containing your statement and the other your annexes. Can we then go on to just confirm your statement? If you look at the statement file, the first document should be your statement. Can you confirm that this is a statement that you have prepared for purposes of giving your testimony before the commission?
That is correct.
And if you can go to page 25, is that your signature?
That is correct.
And do you confirm that the contents of the statement are true and correct of your knowledge?
That is correct.
All right, thank you. Chair, Commissioners, I've discussed it with the witness and I have informed the witness that we have read the statement. So our approach to the statement this morning will be to highlight certain aspects and then we will focus in on the parts of the operations manual and then his involvement in the cases that the Commission is looking into. Mr. Sesoko, if we can then start at page 2 of your statement where you deal with your background and experience, can you summarize for us your background and experience with particular reference to paragraph 4 of your statement?
Just state only the salient background qualification. Just it's quite a.
We'll do so, Chair.
We have read it.
I'll do so, Chair. Basically, my career in the criminal justice system started as a prosecutor.
Sorry about your current position at IDAC to the other.
All right. My current position at IDAC is the National Head of Investigation and Operation. I assumed that position in October of 2021 as a seconded employee from IPIT and then formally transferred to the NPA in 2022. Before then, I was the head of investigations at IPIT, and then I had an illustrious career within IPIT and its predecessor, ICD, from 1997 until 2021.
And ICD,
and before then,
my apologies, and ICD is?
The ICD is the predecessor to IPIT.
Yes, it's the Independent Complaints Directorate.
Independent Complaints Directorate.
Thank you. And prior to that?
And prior to that, I was a prosecutor within the Department of Justice from 1993 to 1997.
Thank you. You then say in your statement, after you deal with the various trainings you've attended, that there are two features of your background that will be relevant to what we'll be discussing at paragraph 7 of your statement. Can you deal with those aspects?
Thanks, Chair. First, I'm the former head of investigation at IPIT.
Sorry, so why is the statement? Oh, there it is. No, I wanted to ask why it's not being flighted. It's on screen now.
All right. And together with the former IPIT Executive Director, Mr. McBride, I testified before the Zondo Commission about police corruption. When the ID was established, investigation relating to police corruption arising from that testimony were authorized and moved into ID, which is now IDAC, together with certain investigators who worked on those matters. That is how investigators such as Mr. Mansara Peso, Tetimani Binang, Mr. Anthony Sihas, and Mr. Stanton Govender came into the IDAC. On the 20th of July 2026, I forwarded to the ID documents that I was able to source relating to discussion between the former ID and the acting executive director of IP relating to the process of case handover to ID and secondment of IPIT investigators in IDAC, then ID. The documents are attached and marked MS01. The bundle of document is a memo from the former ID, Advocate Cronje, and has annexures A to H. Annexure G of the attached document is a list of cases that were requested from IPIT. Chair, I put this in the statement because the Commission asked me to deal with this, but also importantly that Advocate Johnson testified about it, that he had asked me to get this information, assisted to get the information from IP, and this is the information I got.
Just out of good morning, are you an attorney or an advocate?
No, I'm not either.
So you were
Yes, so I moved from prosecution side and went to side.
So in your role at IDAC, you cannot prosecute?
No. Secondly, my own history at IPIT informs the approach I took to the matters described below, as I explained under the heading why I did not insert myself into.
Thank you. Chair, you recall that during Advocate Johnson's testimony, the Commission wanted to know which cases were transferred from IP to IDAC, and that's contained at page 47 of the bundle of documents that is included as annexure MS01. It then also includes requests for deviations for members, some of the members to be transferred, and those are the documents that follow annex. The second aspect of your statement that I'd like us to turn to is in the mandate of IDAC. Now, a number of witnesses have expressed explain the mandate of IDAC. So if you can, at a snapshot, what exactly is the mandate of IDAC? You don't need to explain at length.
So, Chair, the mandate of IDAC is to investigate complex corruption, commercial crimes, high-profile commercial crimes, and financial crimes. And those investigations should be looked at within the context of other statutory offences and common law. The primary issue is that they must be complex, high-profile corruption, commercial, and financial.
And is it that when it's a corruption case, it must have the features of being serious, high-profile, and complex, or is it all each one of those three? Serious, high-profile?
Yes, so it must be either of those, but it should be there should be complexity too, because otherwise you've got other law enforcement agencies like DPCI that deals with similar corruption. So at IDAC would then concentrate more on the complex, high-profile ones, those commercial ones that are high value.
And then we can then move to the operations, or the operations model of IDAC. And you deal there with it at paragraph 10 of your statement. And I think the DDP advocate Sirunye dealt in some detail on the principle of prosecution-led investigation and what their roles are. But can you, in summary, deal with, at its core, how do you operate in IDAC?
So how we operate at IDAC, Chair, the prosecution-led investigation presupposes that it is a multidisciplinary team that is led by the DDPP. It will have a lead prosecutor, a lead investigator, a lead criminal investigator, a lead financial investigator. Then there will be also other lower-ranking investigators and lower-ranking financial investigators. You'll also have data analysts as part of the team. In practice, the DDPP will be the one that would normally submit an authorization for investigation to the ID and even propose the team that is designated into that litigation to be part of that. Once the ID approves that authorization, then the project manager who is designated to that project will then convene a team meeting of everyone who is part of that team. Then they will start to plan for that project in terms of the investigation and prosecution strategy, and they will then develop a project plan for that investigation. Then there will be taskings that will be issued to the different functionaries who will then execute the tasking as per the project.
So in essence, you say that the DDPP lead a multidisciplinary, which consists of the various functionaries that you mentioned. Now, you then say at paragraph 11 that in terms of how the flow of information or how reporting happens, is that then these report one to the ID, and then in another sense, they are then the operational management committee, which you would be the chair of, where they report.
That is correct. So the DDPPs report directly to the ID. The operational management committee, we call OMC, it's for the management to monitor progress on these investigations as well as the prosecution thereof, and to see that matters progress as per the project plans. And where there are issues that need to be addressed, then there are recommendations made of how this should be addressed.
You mentioned the OMC in the past tense. You say you used to chair it. Why the past?
Yes, Chair, I used to chair it. What happened is that when I came back to work after my unfortunate incident of kidnapping, I found that I had to change. A decision was made that the DDPPs would now chair that committee.
Would they rotate because there's what, 4 of them? Or
yes, they would.
Come back.
I think it was 13th of January 2026.
And was an explanation for that?
No, there wasn't.
Advocate Sirunye described the relationship between the Ds and your office as a dotted line of reporting. Would this new arrangement then change that, or is there any more that's done to
Chair.
Or your office, sorry?
Chair, there isn't a dotted line of reporting. The DDPPs do not report to me, they report to the ID. What happens is because I'm involved with operations, hence I was chairing that OMC, was just to oversee that all the projects are executed in line with the plans. So in practice, what would happen is that the project managers would then report if there are any issues in the projects, and then they would report to me. I would make interventions to unlock whatever issues that would have been raised with me. And if they needed escalation to the ID, then I would escalate those to the ID. And what would normally happen also is that when the teams are satisfied that investigations are complete and they are ready to enroll a matter, then a meeting would be called. Some colleagues call it the panel, as I had Advocate Sirunye testify. A meeting will be called where myself and the ID and the DDPP responsible for that matter will get presentation from the lead prosecutors about that matter, and to assess if their decision to enroll is something that is valid and based on the factual basis based on their presentation. And then once we are of the view that it's ready to be enrolled, then the ID will the stamp of approval, and then it will then be enrolled, and other processes will follow in terms of the takedown.
Just to be sure, do I understand you to mean, except for being divested of your power to chair the OMC, your powers remain the same, or not?
Yeah, the powers remain the same.
Thank you.
This process that you describe, where you, the ID constitute panel where is made and a decision is made, eventually a decision is made whether matters are ready for enrollment, for a final decision by the ID. Did that continue to position until last week while K. Johnson was still there? Or are you describing historic, that's how it used to be? Are you saying that has continued to be the case even after you were removed?
Historically, Chair and Commissioners, that's how it, in recent past, it was no longer like that. But in most of the matters that we dealt with and were able to enroll, that is how.
Thank you.
In your description of what is reported at OMC, I got the sense that it was operational matters that were reported. You are both the head of operations and investigation. So at that level, you also give input on the investigative side.
That is correct.
So you deal with things like capacity. Would it extend to the approaches in the various matters?
As it relates to investigation, yes. When it comes to prosecution, it's only the prosecutors that we deal with. But when it relates to investigation, we make our in relation to that.
Just clarify, do the investigators and IDAC and all those, do they report to you as head of investigations? How does it work? Who do they report to?
Only Mr. Dylan Perumal and Chief Boy reported to me as Chief.
Perumal and who?
Boy. Chief Boy, yes. Nico Boy. So how the structure used to look like, all personnel who are under investigation will fall under my command, to use that word. So the chiefs will report to me, and then those that fall under them will report to them. For instance, the senior investigators will report to the chiefs, and then the investigators will report to senior investigators or direct, depending on them.
And then the would they report to?
The prosecutors will primarily report to the
and then the DDPPs
in
will
the different
report
levels.
to Advocate Johnson.
And then the DDPPs will report to.
So you were Mr. Perumal's boss?
Yes, I was.
When did that change?
So what happened is that after I came back, I found that apparently there was a strategic plan that was convened that came with changes to the extent that even the reporting lines were changed. So Chief Boy, Chief Perumal signed their performance agreement to Advocate Johnson, and not with me, as it were.
So since that plan, they have been reporting directly to the ID?
Yes, with their new performance. Even though administratively, I would sign off on their, which is the letter that the ID issued with me after I raised the issue with her, and then she issued me a delegation letter, basically to deal with administrative relating to their work, like leave, travel.
So you were divested of more than just the power to chair the MOC. Remember, I asked you whether the only power you were divested of was chairing the OMC, and you said yes. So
that's my mistake, Chair. Yeah. I didn't think about this one at the time. Yes.
Yeah. No, thank you. No problem.
How long were you away from work? You say you came back in January, having been away since when?
The incident happened on the 6th or 7th of November. So I was away from work from then.
For about 2 months.
About 2 months.
So just to be clear, prior to this, the roundabout that you said on the 8th of November, Chief Perumal and Chief Boy.
Yes.
And then at paragraph 12, we deal with that the teams don't share the details of these matters, and that has been explained. But one thing that I was particularly interested in is what you say about reporting of the ID's matters at OMC. Can you explain what you say there in paragraph 12?
So, Chair, there were matters that would come directly to the ID's office, and collected in the office, they would call them ID matters, because the ID would have taken decision on those. And in the OMC, they wouldn't be discussed. All other matters would discuss except for those, because of it was indicated they were sensitive. So the CI matters would be one of those where there wasn't discussion really about them, except in those teams where they were.
Outside of the CI matters, what other matters existed that were ID matters?
I think one matter that I can think of, the speaker matter. There's also Project Golden.
My apologies, Project?
Project Golden.
Golden.
Yes. So those were the matters that were authorized from ID. But my understanding is that those matters, even though they were authorized from ID's office, for instance, the speaker matter, she did call a meeting. I was part of that meeting, and the assessment of that matter was done with us and the prosecutors. The Project Golden, I wasn't part of that assessment, but I'm informed that the DDPP responsible did the assessment, the prosecutor, and that's how those matters were authorized.
Just to be clear, if the speaker matter, as I understand it, and you've confirmed it now, you were involved in that authorization process?
Yes, so the ID called a meeting to say she received matter, and that invited also the prosecutors that they must assess and then advise. and then he was in fact advised. We did have a conversation about it, and then I think there was a general consensus that our mandate, but prosecutors went further to do further assessment and then advised that it has followed our mandate, the authorized, and an authorization prepared for it.
So although it came in through her office, it ran through the ordinary process
Yes.
of an evaluation
Yes.
and recommendation for her to authorize and proper authorization.
Yes.
Now with the Golden matter, you say that similarly there, although you weren't involved, a DP was involved in the processes.
Yes, and other processes.
So the only one that is truly different would be the CI matter, because we know from testimony before this commission that it didn't go through any of that.
That's correct.
This was Project Golden. You were not part of it because you were excluded, or you were not. I'm just trying to understand why you were involved with the speaker matter or referral, and then you don't get involved with the Golden.
Chair, to be honest, I sometimes the decisions that Heidi would take, I wouldn't really understand. Sometimes she would say to me, so I forgot to inform you, and then inform me of a matter after the fact that she had taken this. So it's the same also with Project Golden. From what I understood, she called the deputy, discussed the matter with us, and then they then did the assessment and prepared submit to her for.
One of those that she said, I forgot. I'm just trying to understand, you were at work in that period, I assume.
Yes.
You don't become involved, does she then subsequently, I forgot, or she says nothing to run involved with?
Yeah, I only got to know about it when I was discussing with the manager. Then I found out that there is this authorization on Project Golden. When I inquired further with the deputy, then the deputy explained to me how it, from what I understand, it's a SARS referral to IDAC. So that's how I got.
You know,
So
Mr.
I must also indicate, Chair, so that there was a point, I just can't remember exactly when, it might have 2 years or so earlier, where she called me into a meeting with the management of SARS, and there was a discussion about the same issue, but it was much bigger, from what I understand. But the conclusion of that meeting was that because the matter is already with DPCI, and because of how huge the investment, we didn't have enough resources to deal with, and it will be left. So I only learned, it must have been a year later or so, that now it's been authorized. But it's only some part of that, not the entire.
I have to ask, and I ask because we now know a lot happened, a lot of wrong has been done in IDAC, so I have to ask in the direct questions. One of the matters, she said, forgot.
Chair, we never spoke. She never said anything to me about it. I'm just saying that sometime or from time to time, there will be decisions taken where she would then, when I'm in a meeting with her, and she say, hey, Sesoko, I'm sorry, this is what happened, I to inform you, but not still on.
And then just
Sorry, can you just give us a picture of how your office has yours up position or location? Are you here and then there are several office twins that side, or are your offices next to each other? Just give us an idea.
They are not next to each other, but they are not far from each other. We are on the same floor, so slightly on the other end, on the other side.
I just wanted to...
It's a long passage. Her office is in the middle of the passage, and then my office is on the other end.
I just wanted to understand. Okay, for example, if you're right next door to each other, I just would not whatsoever. Not that I understand it now. Anyway.
Can I just ask, the impression that I had gained was that through your intake process that I set out in your manual, that process result in a record or tally, if you like, of matters that are coming. Describe, you tell us your process. It comes in terms of the manual, and evaluation, some would get on, and process get on. So I would expect that somewhere you have a record. I would expect the include become the ID. And I would have thought by virtue of your position, I assumed by virtue, you would have a repertory of that. We asked you what to print it off, director. What does it mean then for matters such as this, where the Project Golden, you know nothing about? It's the ID matter. She has spoken, key and investigation run. When it comes to your record, you know, what does it mean for matter in practice?
So in practice, Chair and Commissioners, when a matter is authorized, it goes to the project manager responsible for that project. Then they would assign it a case intake number, and then it will be put on a register, a case intake register, which have all the matters that are within IDAC. So we created that, especially when I came in, it was there, but it was not fully developed, and then I said that the register becomes fully developed and be able to cater for all the different scenarios that we needed for engine purposes and also for performance. So that register will have all these matters. So how I get to know, for instance, is when I see in the register does not have full details of the matter, except like in that case, it's CIN number so and so, and then it's maybe we give it, project has a name, so it will be Project Golden, for instance, in this case. So when I have a meeting with project managers, then I ask what this matter is about. I wasn't aware of it, then they'll explain, no, this is what it's about, and I would engage the deputy consul. So the thing is, that is how we've been operating. And when I came back from leave, I find that also that register is no longer made available to everyone, as it were. And hence later I talked to a matter that I became aware of was authorized in my absence, which I found also.
That's very helpful. It gives meaning to CI, and I've seen CIN a number of times. I didn't think it actually stands for something.
Case intake number. CIN stands for case intake number.
Thank you very much.
Sesoko, what I wanted to know, just one more aspect in relation to case that was deemed ID matters. The first one, Speaker, if I'm not mistaken, was in 2020.
Yes, I think
correct. Now, when you sit at OM, and this ran through the processes we know, and you were involved in the process. When you then sit at OMC and you no longer get reports about this, was this then raised with the ID?
We had a discussion about these matters, and her view has always been that these are sensitive matters that must remain like that. However, when a matter has been enrolled, then we then talk about its process, even at OMC, whether it's postponed for trial or whatever. But at the stage when there is still investigation on it,
There was resistance.
They weren't discussed at the OMC.
We
just understand how explained. I accept that when people are working, that you have a system where one team that's on the matter, the team, think about it to know, principle to know, and that's how you manage. But the idea that matters are sensitive, therefore, they will not be discussed with you. For example, when you hold a particular, you're head of it, you have taken oath, you are bound to the same principles or the same rules as your ID for confidentiality laws, you've broken the law. It applies it to her. How does it get explained, and how do you reconcile with you can't know, another DD will know, but you can't know it. You're not subject to the same rule. Can you just explain to us how it's explained in the office and how that consignment you hold?
Commissioners, some of those sensitive matters, as it were, like I indicated, like they were discussed. The explanation about sensitivity stems from the fact that they are matters that sort of the ID owns. They come from her office. She decided on their authorization, and then she decides also who, as opposed to other matters, who is designated in those matters. So, for instance, other matters, as I indicated, it will be the deputies that decide the designations of members who will be part of that team. However, in those matters, the ID herself will decide who she wants to be in those matters. So that is how it worked. And I would from time to time get complaints, for instance, from even deputies that you find there are resources in their projects who have been roped in to the ID matters, and they would want them to task them on other matters. And an investigator, for instance, will say, no, I'm busy with an ID matter, and there would be those kind of issues that I have now to deal with to say, how do I then assist with resources so that the other projects do not suffer. Some resources are put on those matters.
And by that you mean they will be taken out of their team, because
yes.
As I understand it, they
yes.
all belong to those 40. So they would be taken out of those and plonked elsewhere altogether.
Yes, on this.
Maybe lastly, so it sounds from your explanation, in the answer to the chair, that there was no objective criteria. You've told us about criteria and the scoring about matters that eventually came out. The ID matters, as you call them, there was no objective organizational criteria. It was entirely up to the ID. She gets a matter and decides, however she gets it. She came to her direct, decides whether they treat it like the PICA matter or gets treated like your Project Golden matter, were entirely.
Yes, that is correct, Commissioner. And that's why I'm saying not all, in fact, almost all matters were dealt with in line with, what I previously said about, being assessed and so forth, either by me or by my other colleagues, the deputy. Those that she made decisions on, that's where there was a difference, was the approach would be different as compared to others.
And just one more question on this. At a stage where it's clear now, you are now implementing this process where ID matters are not discussed, at a stage that you can't do your job because there are complaints coming in about resources, there are investigations you know nothing about. Do you again raise this as an impediment to your job and to function?
Chair, we would always find ways, because what we always understood is that when they came from the ID's office, those are priority. So we'll always find ways to make sure that these other projects, still continue with whatever, resources we have, move people around so that they can. So, for instance, if there is a particular tasking in another matter, and then the resource working on another matter is being used in the ID project, then we would find another resource somewhere to deal with whatever task is done on this other matter. So we'll always find ways to ameliorate that challenge.
Now, you've described in detail the intake process, and we've heard from other witnesses about how it works and how it ordinarily unfolded. Unless the commissioners want to go into detail, my proposal would, because I think what's different, your explanation of why this multi-level process was important. So could you deal with that, unless commissioners, there's a question around what was set out in the ops manual about how the ordinarily works.
Shouldn't perhaps start from paragraph 16 or not?
Chair, my proposal was that
We skip even that. So where do we start?
Deal with why the multi.
This is about which paragraph?
At paragraph 3.
Oh,
Yes.
let's.
Just for the record, in some, the paragraphs before deal with how matters reach IDAC, the registration process, verification and screening, the intake assessment and the scoring process, the authorization of investigations, the planning and conducting and finalization of investigation, and thereafter securing attendance and processing and ultimate closure of matter. What's different about your state deal with why this process? We then go to paragraph 2.
Thanks, Chair. Maybe before I deal with that, so I don't want the Commission to be left with the wrong impression. The manual was approved, as I've indicated, and other colleagues have also. It was shared with all the colleagues in IDAC, and when new people come, those responsibilities will always work. The fact of the matter is the intake process did not operate to the T as provided in the manual. So that is what the reality was, as my previous explanation had explained about how some of the matters came in. But even though it was not the T, but most matters would go through that assessment process. And later in my affidavit will show that, in fact, most of the matters that we did in IDAC are matters that came from the Commission, which came in as a result of the presidential process, and therefore did not go through this process, but rather as a result of presidential proclamation, and the former ID would have authorized them because of that presidential, and wrote to law enforcement agencies like IP and CI, and requested all those matters to come to the ID then for them to be indicted. So I just wanted to clarify that.
Advocate Johnson said, for example, about Mr. Adams' referral. She said she did not discuss that with you because it was a simple matter, and she was of the view that she'd handle it all by herself without involving you. Are you aware of any instance, or rather, how should I? Are you aware that the fact that a matter was simple, whatever that means, that was a factor or a criterion that could be used not to involve other people at the initial stages of a matter or of an intake?
I'm not aware of any except for that.
And that's not an issue that was ever discussed within?
No.
So she never said, with simple matters, I will not bother you, Mr. Sesoko?
No. The decision to authorize that matter was not, as I will continue my testimony, you'll understand what happened.
No, I just wanted to understand the criterion she said used these crimes.
I would have asked the same question in that way.
And then just on the issue of the manual, so to the extent that Advocate Johnson testified the manual was to draft, she would have leading this at its light of light.
I don't understand why she said it. The manual was signed by myself and her, and then at her instruction, it was distributed to all IDAC staff.
Just remind us for purposes of the record within it, but for the record, when did she and you sign it?
I have a date, son. I can't remember the paragraph now, but I do indicate that in my affidavit. I think it was 16 October 2024, if I'm not mistaken.
Chair, it is at file 10.
But in the affidavit, it's paragraph 20, top of foot of
yes,
page.
Yes,
foot
paragraph,
of page 11,
paragraph 26.
Top of page 12.
Yes.
But Ms. Bowe wants to take us to the document itself.
At page 10 of page 10 of file 10.
Okay, let's so it was not a draft, it was distributed to.
Yes, and I do indicate that it was distributed on the what we call ID comms, where it would all staff on the 22nd of October.
Thank you.
It differ much from version 1.
Sorry,
Just look at your screen. See that there's amendment to the heading, and version 1 was signed on 83, and then the current version is in October. The current version differ much from version 1.
So, Commissioners, version 1 was never signed. It was a discussion document. As you'll see from my affidavit, I indicated that it was a consultation. So we had consultants that were assisting this document, and then they would send a draft. So the version 1 is the draft that was first sent. We had to engage with it and then make changes on it. And when everyone was satisfied that Gen 2, a product of what we are on, then that's when it was signed off.
And the way this work at IDAC, in other organizations, a document gets signed, give date, and sometimes give date is some time in. So with this manual, what was the effective date? Did it take effect from the moment the two of you signed and authorized it?
Yes.
Thank you. Mr. Sesoko, then if we can then go to why the multi-level intake process matters.
Yes. So I emphasize the intake and case selection process, case selection stage of the process, because it is deliberately multi-layered and collective. Its stated objective is that case selection is transparent, objective, auditable, and defensible, and that it cannot be manipulated. There is, however, a further and equally important object: to insulate ID from any allegation that IDAC is targeting particular persons or picking or declining cases without proper basis. If a matter is received as assessed and scored and recommended by a team and a committee before it reaches the ID for authorization. The ID decision rests on a documented, and the ID is protected against the very allegations that are now being. I was closely involved in creating this framework. I drafted the case intake process that became a case selection criteria, Annexure A to the manual, in August 2022, and I'm a signatory to. The purpose of that process, as recorded in the document itself, was to establish a case intake and selection process that is impervious to undue external influence and that ensures IDAC is not manipulated to select cases furthering a personal or political agenda. It provided for case intake to assess matters and advise the ID. In 2024, IDAC embarked on an inclusive process involving members across the department to produce the operational manual, which sets out processes in detail and incorporates the intake criteria. The operational manual version 2 was signed by me as head of investigation and operation and by the ID on the 16th of October 2024, and it was shared with every staff of IDAC on the 22nd of October 2024 at 11:31. It is in substance and in the manner of its adoption of the framework contemplated a single designated intake point together with the case intake. It motivated for a dedicated post to fulfill this function.
I think you say here I, not it. I motivated.
Oh, sorry, I motivated for a dedicated post to fulfill this function. A person who would receive all incoming complaints, conduct first assessment of whether the matter falls within the mandate, refer qualifying matters to the case intake committee, and act as secretary to that committee. The object again was to ensure that the ID does not take intake decisions alone, and that she is insulated from allegations of targeting a particular person or having an interest in particular investigation. The job description for that post records these functions expressly, including that the incumbent is to receive and register all incoming cases, evaluate whether they are within mandate, refer out of mandate matters, convene the case intake committee, and act as its secretary. See the attached description mark MS1. I initially designated the post investigating coordinator. Through the organizational development and job evaluation process, it was retitled Deputy Director, IDAC Operations Support and graded. The post was placed before the job evaluation panel on the 25th of November 2025. The recommendations were approved by the minister on the 31st January 26. The post was graded at level 12 and feedback on the outcome was provided on the 5th of March 2026. I attached the confirmation of the job grading marked MS2. The process to create and fill that post was, however, not carried through. When I followed up with the organizational development unit, I was informed that they had been instructed to stop the process on the basis that the post would not exist and that the responsibilities would not lie with pending restructuring. The outcome was not communicated to me at the time. I only learned of it on the 27th of 26th.
You say this in the passive voice. Say you were informed that they had instructed to stop the process. Who had instructed them?
The ID.
Thank you.
You can continue.
The consequence is that the single intake point and the case intake committee were never fully operationalized. In practice, matters continued to be received directly, mainly through the IDAC spokesperson, including by the ID herself and me, and were not always routed through the collective assessment the manual and the case intake criteria contemplates. It is against this background that I raise a concern of general application and not as a comment on the guilt or innocence of any. Where a multi-level intake process is bypassed and a matter is received, assessed and authorized by ID alone, the very protection that the process was designed to provide objectively, auditably, and the insulation of the ID from allegations of targeting falls away. That, in my respectful view, is the significance of the process for the Tinoi. I'm aware that the operational manual has been described before the Commission, the draft. I recorded that the manual was signed by the ID and me and was distributed to staff, to every employee of IDAC as an operational manual. A review of the manual was subsequently undertaken by a single person, which is different from the consultative process by which the manual was originally made. In my experience in government, a policy of this kind is developed and reviewed through a consultative process and remains applicable until any review is needed. I have not seen the review.
Was there an actual review?
Yes, I've learned that there was the actual review.
Have you seen a document?
I have not seen.
How did you get to know that there was a review?
It was discussed in my discussion with the ID. He indicated that he had Advocate Mohammed do the review. We also had an investigators working session where Advocate Mohammed was in attendance, and she indicated that she was in the process of reviewing the manual.
Is Advocate Mohammed within IDAC or is there?
She is within IDAC.
All right.
What position?
My question, is she a prosecutor? What's her position in IDAC?
Yes, she's a senior stater.
Not at the level of it.
No.
All right, thank you.
As matters stand, you say you haven't seen that reviewed manual. Know that there is a manual. To your knowledge, as matters stand, what is applicable, even if it's not this new version, or your knowledge that version is to be applied?
Chair, as a matter of process, as long as the reviewed manual has not been approved, the original manual still stands and
one of
remains
the-
operational.
You would be one of the approvers by virtue of your.
I'm not sure with the reviewed one.
So you're
Because
saying-
I was not part of the review.
No, I'm just trying to understand. You were signatory to version 2.
Yes.
And I have assumed by virtue of your, as you are the head of.
Yes.
So I assume that's why you signed.
That is correct, because it was, as I said, a consultative process, and we would discuss extensively also with the ID, the other colleague. So after that consultative process, and I presented it to her, we agreed that it's ripe for approval, and then that's why I signed off. The review process, as I said, I wasn't part of it, so I cannot say to the commissioners now that I was going to sign or not, because I'm not sure.
What does the manual say about consequences for failure to follow its process? Does it say anything at all?
Yes,
so say, for example, a case comes in, the case assessment report is not there, that CIS process that you mentioned, I hope it correctly. If all of those processes are not followed, what does the manual say?
I think the manual does allude to the fact that failure to comply may lead to it.
But the ID can't herself. So if it's the one who's flouted the manual, does the investigation that out manual but followed? That's it.
Commissioner, obviously, if the ID herself flouts the manual, the person that she reports to will have the responsibility.
So that would be
the NDP.
Does the manual say it applies to her or only those below her? It's clarified. Does it apply to everyone at IDAC or only those below the ID?
It applies to everyone.
In the ID.
Let me ask a related question. Are exceptions provided? There is exceptions not to follow the process strict. Are there provisions for exceptions?
Chair, on the top of my head, I can't remember if there were exceptions. But my understanding of the architecture of the NPA Amendment Act is such that the investigating director has got all the powers to decide on, including, so for instance, even with authorization, that he can decide on authorization.
Can you please look at the manual during the adjournment and see if the manual itself does provide for I hear you on what you say about. Did you refer to a specific section?
Yes, it's section 28.1.
20.
Yes.
Isn't 28.1 about investigation?
Yes, on the authorization. Can remove.
But I'm not sure that that answers my question about exceptions with regard to the application of the manual.
Yes, no, that does not deal with that. I will.
All right.
Mr. Sesoko, you said that, I think it was in response to Commissioner Khumalo, that the NDP that would have to deal with that matter.
That is correct.
And how would the NDP know?
Obviously, there should be reports that go to the NDP.
And the reports would come from the ID?
No. If I understand you well, you mean if there is an issue about non-compliance?
Yes.
Yes. So if there's an issue about non-compliance, it means employees who become aware of the non-compliance, who reports it with the NDP would have to take action.
So essentially, employees report to the NDP?
Yes.
You know, the natural question that follows is, in these instances, we know there was flouting of this manual, and you were well aware of that.
Yes.
Did you report to the NDP?
I personally did not report, Chair, but I'm aware that I was informed that there were a number of that were referred to the office, the former NDP.
I may have misheard you. Did you say that cannot or you did not report?
No, I did not.
Is there a reason?
Chair, I don't have a reason why I did. I think I say something about it later in my affidavit. I have been through a lot, and when some of these things happen and you hear that, there were reports that were reported to the former ND, and there was nothing that happened. I just felt that it won't assist.
Now it's like you were part of. Two of your colleagues show us that they wrote 24-25. Although nothing was done, it's clear from their emails and their comment that they raised about you now have to account to us. And because you did not look like you were part of the problem, you were part of the reason why the manual was not.
Chair, I will take responsibility, but I had my own personal reason. The fact of the matter is, these issues, as they were raised, and you would have seen in the emails, the colleagues were sending these emails to the ID herself, and I'm copied in those emails. And in bilateral meetings with the ID, we would discuss it, and she would indicate, for instance, his displeasure about the colleagues on how they raised these issues or raising these matters, because she believed that there was nothing wrong in how they were approved. So I left it.
You mentioned in your response that you were copied. In some of those emails, they were sent directly, and particularly, I know one of the witnesses, Mr. Rapesu, you would have been also his supervisor, because that would have come out in the investigation side of it. So, and you say that in the discussions with the ID, she would raise displeasure about them raising issue, and in response to that, nothing.
Yes, and as it relates to Mr. Rapesu's issues that she raised, I took them up with Chief Perumal. And in those discussions, Chief Perumal would make it look like there's a difference of opinion in the investigative approach. So part of what I would want to do is to try and get the team to be coherent. So I tried to sort of mediate whatever conflict they have about and how an issue is dealt with. So that's how I approach.
But I'm sure you could tell that there's a difference between what you call a sort of a difference in approach, or when Permo says it's more of a difference in approach, that there's a difference between that and blatant disregard of rules, the law. When you are then dealing with those issues and that occurs to you that that's happening, surely there's more to be done than just building coherence.
So as far as I can recall, the issues that Rapeso raised with me was in relation to the process of the dockets and the issue relating to one specific witness and how that had been approached, and the instruction from Chief Peruma, which he was uncomfortable with, which, as I said, was discussed. But not long after that, that is when he was removed. That's how I recall it.
It's fine. I think we will, in the sections dealing with your involvement, deal with some of the issues that were raised. And I think the records will show that it's more than just a difference in approach. There was actual disregard of both your internal operations manual and, I would say, the law as well. We can then move to the next section of your state, which deals with your involvement in crime intelligence related investigation. Chair, uncharacteristic to see.
Let us start.
But
Let us start. Were you going to say?
I was going to say, because this is the second half of minutes.
Let's start. Yeah.
No
We
problem.
can stop at 11.
Mr. Sesoko, then we can move to paragraph 33, where you deal with your involvement in the crime intelligence related matters.
That's correct. Before dealing with the detail, I stated at the outset that I had no direct or substantial involvement with matters. I was not included in the team, and in the ordinary course excluded. Sometime Chief Perumal would mention something to me in passing about a case and how good evidence he had obtained. I think there were a number of meetings where I was invited, which I cannot remember details of. I came to learn of aspects of the matters largely when complaints were reported. Given the position I hold and the leadership role I ordinarily play, the exclusion was unusual and had not previously occurred in my time at IDAC. I was drawn in only in discrete issues. There were, in essence, 4 occasions on which I had involvement: assisting Mr. Rapeso to obtain the docket, a meeting convened by the ID to discuss the CI investigation and a report to the minister, a conflict between Advocate Ramsamy and Chief Perumal, and the disciplinary and legal matter concerning Mr. Rapeso.
I think it's important to mention which minister. Please read.
Minister Mkun, Minister of Police Mkun.
I just meant of police. You just said
Yes,
minister.
Minister
only.
of Police.
Thank you.
You can then deal with the first issue, which is when you were assisting Mr. Rapeso to obtain the docket.
On or about this December, Friday, I received a call from an IDAC investigator, Mr. Rapeso, who informed me that he had been instructed by Chief Lt-Gen Perumal, to fetch the dockets containing the allegations against the CI officials from the station, and that he had been told the dockets were held by the inspectorate with General Jacobs. Because of the level involved, he asked me to. I telephoned General Jacobs and told him that the investigators would like to see him in relation to the dockets in his possession. He did not inquire why. He did not seem surprised. It was a very short conversation, and he said that I could come and see him. I think I meant he could come in. At the time, I did not know.
He is in Mr. Rapeso.
Rapeso, yes. At the time, I did not know whether the investigation was authorized. I assumed that if an instruction to obtain the docket has been given, the investigation must be authorized. I later learned that when Mr. Rapeso sought to collect the dockets, General Jacobs asked for a letter. Mr. Rapeso reverted to Chief Perumal. The ID wrote the letter. The letter was sent to General Sintumule, and she then dealt with General Jacobs, which is how the dockets were ultimately obtained. I was not involved in those later steps, and know of them only from what I was.
I think at this point we may take let's adjourn and resume at 11:30.
Good morning again. It's 29 minutes past. We are ready to resume. Please make sure that your cell phones are on silent. Thank you.
Yes, Ms. Powell.
Chair, just a small matter of housekeeping. I had earlier asked the attorneys to make copies of a set of screenshots. They should be somewhere in front of you, marked CJC 400.29. They'll be added to the next exhibit file. Essentially, they are screenshots of email correspondence involving the CI matters, and these come from Advocate Ramsamy. They are not on the record. They will form part of her upcoming testimony, but I would like to make reference to the fact of her sending the emails at some point during the testimony, so I just thought to provide everyone with, but it's not for use now.
When documents are handed to us at hearings, I always make the request that the place where they should be in the files. I noticed, I think yesterday, that some documents are in the pockets, file pockets on the inside covers, and that is not always done. This is a request I've always directed our attorneys, the committee have not always been.
Chair, I'll ensure they not have lunch until they've inserted them in your files. Before the tea adjournment, Commissioners, before we return to the state, Chair had asked the witness to have regard to the operations manual. Perhaps we can start there.
Please assist, Mr. Sesoko.
Thanks, Chair. I think the two issues Chair wanted me to address was the issue of applicability. That issue is addressed in the manual, page 18 of the manual, where it talks to scope and applicability. It reads, the manual is designed to provide comprehensive guidance and standardization within IDAC and encompasses all aspects of the IDAC's function. The manual is intended for use by all personnel working within IDAC, including investigators, prosecutors, support staff, management. It is applicable to all levels of the IDAC. So that is the applicability part of it. However, in relation to consequence for failure, it's not provided for.
I think I'd also asked a question about whether it provides for exception.
Oh, yes. I couldn't find anything relating to exception.
Thank you, thank you.
Thank you, Chair. Mr. Sesoko, if we can then return to the section that you dealt with before the tea adjournment, and that relates to assisting Mr. Rapesu with the dockets. Am I correct to understand that this would have been the first time you learn of the CI matters?
That is correct, Chair. The call I received was already after hours. If I'm not mistaken, it should have been around 6, around there in the evening. And as I said, after the conversation with investigator Rapesu, I called General Jacobs and facilitated that. And then I gave Mr. Rapesu that feedback. As I said, that only later I've learned what happened.
Yes. My interest is in when he tells you he's seeking these dockets, and he's essentially alerting you of this new investigation. This was the first time you're finding out about that investigation?
Yes, it was the first time I found out that there is such an investigation. As I said, that when he said that he got the instruction from Chief Perumal that he must get the dockets, and he's been to a station, the station said, informed him that they are with Inspectorate. And that is why he was asking for me to assist for the facility. I assumed at the time that it must be authorized, because otherwise why would you go and look for the dockets without an authorization? But I did not have that discussion. All what I did was, because he's asking me to facilitate, I just facilitated that. And then, of course, I learned later that there was this matter which has been.
So in this instance, you are now finding out that there is Chief Perumal is issuing instructions related to an investigation you know nothing about.
Yeah.
And at this time, Chief Perumal was reporting to you that,
Yes.
Did you then go to Chief Perumal and say, what is this investigation?
Yes, I think subsequent to that, we would have had a discussion with Chief Perumal. And as usual, with these matters, where he says, no, it's a matter that comes from ID or investigate.
Oh,
so that would have been subsequent to my discussion with Mr. Rapi. In any event, I would have expected that Chief Perumal would brief me about it. But as I said, that it was a test conversation about it to say it's a CI investigation authorized by ID, and there is a team already working.
And in this instance, did you then approach the ID to inquire about it?
No, I did not approach the ID to inquire about it.
I think then you can move on in your statement.
Okay.
I assume then that you did not see the Section 7.
No, I did not see a section. I had not seen anything in relation to the matter. I did not see anything in relation to the matter. I think the first time I saw anything about it would have been in one of the meetings where there was a president, if my memory serves me.
We can then proceed with the second instance of your involvement in these matters. The meeting convened by the ID and the report to the Minister of Police, that is paragraph 36 of your statement.
So approximately a month later, in January 2025, the ID convened a meeting, which, I don't know what I was trying to say. To which I was called, yes. She said the meeting was to discuss the CI investigation, and that she was required to report or write something to the Minister of Police, Minister Mkhunu, and to send correspondence to the Chief of Staff, Mr. Cedric Nkabinde. The meeting was short, did not go into detail of the case. When the ID mentioned Mr. Nkabinde, I alerted her to his history. In my assessment, Mr. Nkabinde is a dishonest man, and I explained to her there was evidence, including data analysis by our data analyst in the Blue Lights investigation matter, indicating that Mr. Nkabinde was working with or was colluding with the suspects in the Blue Lights matter, and against that investigation.
Sorry. You use the definite article, the Blue Lights matter.
Yes.
Which Blue Lights matter is it?
So the Blue Lights matter, Chair, it's an investigation that we started whilst we were in IP. It's on high-level police corruption. The suspects in that, or the accused, because now they're appearing in court on that matter, are generals in the police. General Patlani, General Ngwenya, it's quite a number of them, and brigadiers and so forth. So that, for me, as I indicate here, it was a concern that she will be
All I wanted was
Okay.
a reader of the transcript must know what blue lives matter you are talking about.
Okay, Chair.
Thank you.
All right.
It's called Blue Lights Matter because it relates to SAPS general, or it has to do with procurement relating to blue lights?
It has to do with procurement and installation of blue lights for police.
Thank you.
Sesoko, please just clarify paragraph. You say the ID convened a meeting to which you were called. She said the meeting was to discuss the CI investigation, and she was required to report to or write something to Minister of Mr. Mkhunu. That report to the Minister of Police, did it relate to the CI investigation?
To the CI investigation.
And did she tell you why she needed to report to?
Chair, I think she mentioned, and I'm speaking under correction because it's something that happened a long time ago, but my memory serves me well, it was about the fact that she had received correspondence from about the CI.
See that correspondence?
No, I didn't.
In this instance, when you were called to this meeting, you still didn't know anything about this investigation?
Yeah, in fact, that meeting was really the first time where I got a glimpse of what this is about.
Do you recall the exact date of the...
I think it might have been the 22nd of January.
When you say you caught a glimpse, you weren't part of the full discussion?
No, it was, I'm saying it was for the first time that I got to hear what is being investigated and who are the targets or persons of
And in this instance, is this considered starting part of the team, or what would have been the purpose of your involvement?
Chair, I reckoned it was to be brief, to get a brief about it, because as I said, I had not known about it. So I think that was the purpose.
Was this before or after Chief Perumal had told you how good evidence that he had obtained was?
No,
It was before. All right.
You can continue. You were at the last...
I
where
advised her to be
advised
careful.
her.
Yes, I advised her to be careful and said that I would not advise her to report to or through him, meaning Mr. Nkabinde. The ID asked me to obtain information from the data analyst so that she would have something she could work with and so that she could advise the minister or the minister's advisor. I did so and provided it to her. The information I obtained from the data analyst is marked MS3. It is a document I provided to her showing Nkabinde's collusion with the accused in our. I understood that there had at one stage been a consideration to charge Mr. Nkabinde, but that this was not done. The DPP at the time, Advocate Law, decided to defer the question of Mr. Nkabinde and focus on the matters involving the police generals and other police officials and service provider, in part out of concern about possible Section 342A of the criminal procedure application to remove the matter from the court roll. I was informed of these decisions. I was not at the ID at the time when they were taken. My concern is that this matter was not dealt with in the normal way. Ordinarily, even a matter received by the ID herself would be referred to me or one of the TDPP colleagues or the chiefs to evaluate whether it falls within the mandate and to advise her before she takes it. Here, the ID received the matter and it appears the decision on it herself. The operational manual, especially as it relates to case intake, was not fully operationalized. Before the ID's testimony at the ad hoc commission, there were very few Section 27 referrals that came through. If they did come through, they would be received by her office. I specifically recall the speaker matter, where she called a meeting about the matter and instructed that it be considered and appointed a team to deal with it. Whereas with the CI matter, I only learned of them when they were already authorized. They were not discussed with me before they were authorized. I did not see Honorable Adams' Section 27 referral either. Even when Advocate Surunya asked me about it, I informed him that I did not see. By way of context, on referrals generally, historically, most of our matters flowed from the Zondo Commission, Mpati Commission, and the Lt-Gen Commission, in respect of which the former ID had already granted sweeping authorizations under the presidential proclamation establishing the ID. Attached is the presidential proclamation marked MS4. There was therefore no need for Section 27 referral. As per practice, most matters are referred to the DDPPs, who then prepare a submission to the ID for authorization. Most matters in IDAC space were authorized as a result of the presidential proclamation. The table below illustrates this point. So the table shows that the security cluster and commission matters are 137 in number, which represent 88% of matters that are within IDAC. And the other IDAC mandate, those are the matters that would have come either from other law enforcement agencies or through Section 27 referral. They are 18 in number, representing only 12% of the matter to IDAC.
Mr. Sesoko.
A matter, we now know that IDAC received a Medicare 24 referral. Where does it fall in?
It will fall under the IDAC mandate.
Mr. Sesoko, you say that very few Section 27 referrals. From previous witnesses, what we heard was that there was only one other referral prior to this. Is that your recollection? And that would have been the speaker matter. And that the one that comes under Medicare, third.
No, as I said, I'm working from our register. This physical information comes from the register. As I said, that these IDAC mandate matters, which are 18, would be matters that either come from law enforcement, which they refer to us, or they come as a result of Section 27 referral. The ones that are Section 27 referral that I can think of right away is like your speaker matter, your Project Golden, and which one am I missing now? Yes, the Medicare one.
Does the register delineate with that number of 8 which ones were Section 27 referrals and which ones emanated from other law enforcement?
No, the register will show that these matters are the matters that came after those presidential proclamation matters, which are mainly from the Zondo Commission, the Party, and the Lt-Gen Commission.
So in essence, the 18 is just matters that came after
Yes.
the Commission matters?
Yes. So they wouldn't have been authorized in terms of that proclamation.
They would have been authorized in terms of your protocol, well,
Yes.
except for Golden and
Yes.
the speaker.
Yes, and of course the CI.
Excuse me?
And the CI
Oh,
matter.
CMA, yes. All right, thank you. Hit with paragraph 44.
After the ID gave public testimony at the ad hoc committee, the volume of complaints increased. My own practice on receiving a complaint, whether a Section 27 referral or an email from the spokesperson, Mr. Henry Matumani, is to assess whether it falls within mandate. If it plainly does not, I respond or refer it out if the position is unclear. If the position is unclear, I meet the complainant to establish whether it falls within the mandate. And if it does not, I refer it to the appropriate agent. This will be done by way of a memo to the ID with recommendation. Of the matters I have received, I recommended only one for authorization. Attached MS5 is the register of matters that went through my office or I became aware of. Of the 27 matters that were recorded in the register, 13 of them were received by me. I only recommended one for authorization. Chief Boy received 5 matters and Chief Perumal received 10 matters. At the time when the CI matters were authorized, I was on duty and no one was acting in my post. I went on sick leave on the 10th of November after I was kidnapped. Then Chief Perumal was appointed to act in my post until I returned to work on the 13th of January.
Just to understand the matters that Chief Boy authorized, when would that happen? My apologies, I'm assuming-
Some of them would have been when, I think most of them is when I was on, if my memory serves me well. I think the register will be able to, because it indicates when they were received. The MS5 would show when they were received, either by me or Chief Perumal or Chief, and what was done with those.
Thank you.
Can I just ask, what informs the decision whether matters get referred? They don't fall in your mandate, I accept that. That is a decision, or the determination, but then you get to refer to other law enforcement. What informs referring or not referring matters to IPID? Because IPID deals with police, corruption, and similar. Is there a principal position that matters never go to IPID? And I ask because in the evidence so far about the crime matters, there are matters where it looks like base of it, the final determination, that this could have been referred to IPID, because from what one understands of IPID's mandate, that particular issue may well have within their mandate. Is there a principal position within IDAC referment?
Chair and Commissioners, the decision is based on the assessment. As we discussed before, that when it has to engage the IDAC mandate, it must meet the threshold of complex corruption or commercial and so forth, high profile. So even if it may involve members of the police, but if it meets that threshold, then it engages the IDAC mandate. However, if it does not, that's where then you have to refer the matter to those law enforcement agents. As you'd see from the register, how I dealt with most of these matters. Some of these complaints, people complain that decisions were taken in the NPA, they were not happy with it, and when I assessed that, I realized that it does not engage our mandate. In fact, they need to do representation or things like that. Or some of the matters, people will say they went to IPID, they're not happy with IPID. I would refer them to the management of IPID, that they be assisted there, or DPCI for that matter. I would refer them to the head of DPCI, exactly to avoid a situation where we take on the matter that are already in the space of other law enforcement.
Let me ask more directly. The case that has been presented before us, you have the General Lushaba loss of laptop story, and IDAC gets involved in that matter. And it seems that IDAC is investigating, ultimately court, is investigating what happened subsequent to the loss of how that was handled. Someone supposed to have lied, a police officer at a police station, evidence that we've had. But on the face of it, it would seem to me that it may well have typical IPID investigate, and yet it is a matter that IDAC investigate and prosecute. Can you explain how? Can you answer my question with reference to that? To those cases, the case looks like an IPID, but what makes it fall with?
True, Chair. On the face of it, it looks like an IPID mandate matter. But at least from the explanation that was that there was quite a number of actions that showed corruption on the part of members who were involved in terms of hiding the true nature of what had happened, manipulating the dockets that were opened, and giving gratification to some of the investigators who were supposed to conduct that investigators with a promotion and so forth. That is the explanation was given in one of those briefings.
If you're absent, and I'm really asking because I want to understand whether some of the problems that we become aware of are the structural problems, competing jurisdictions, and therefore the one body ends up the matters that they shouldn't. So if you exclude the gratification issue here, you receive a complaint. That's how it's, as I understand it. Mr. Adams filed a complaint and said General Lushaba Puta, and there was a cover-up. That's how I found that there was a cover-up. The cover-up goes to Superior, General Khumalo, even though General Khumalo at the time. But the cover-up goes to General Khumalo, but also now someone took an affidavit that the police presented some. Forget gratification for now. On the facts that I'm putting to still said this is an IDAC matter.
If there was no issue of gratification and alleged corruption, it would definitely won't fall within them.
Thank you.
Okay, we can continue with your affidavit. We are now dealing with conflict between Advocate Ramsamy and Chief Paramount, paragraph 46 of your statement.
The conflict, the ID called me into a meeting to help resolve a conflict between Chief Perumal and Advocate Trushanta Rams. As I understood it, the conflict concerned the approach to Advocate Ramsamy as a prosecutor had taken a particular legal view with which Chief Perumal did agree. The meeting was resolved on the basis that the parties should listen to one another, consistent with IDAC prosecutor-led model, and that the prosecutor is ultimately the person who must take the decision on the matter. This is how the issue was resolved. I must, however, indicate that in subsequent meetings where I was called in or brought to my attention, it appeared that these conflicts continued. And Advocate Ramsamy was concerned that as a prosecutor, her views seemed to be overruled by those of Chief Perumal, and that the ID seemed to take more the side of Chief Perumal than her side.
Do you recall how many other meetings related to conflict took place?
I honestly cannot recall. They were varied. Sometimes Chief Perumal would come to me. Sometimes Advocate Ramsamy would come to me. Would have a discussion with the ID. So they were varied. I think because of that and the fact that Chief Perumal was not happy with Advocate Ramsamy, ultimately she was also removed.
You not supervise Chief Perumal's work if there was conflict in the matter because he reported. Was that not an opportunity to then look at what he's done, supervise, provide guidance?
Chair, we would have a discussion about these conflicts, as I said, and in the nature of how our project works, and it's also in the manual that all the discussions in relation to the project must actually happen at the level of the team, so that even when there are these disputes, the matters would be dealt with the team level. So where you would have opinions of the entire team in terms of how the matter should be progressed, what needs to be done, what not needs to be done, and the deputy responsible for the matter would then take the ultimate decision if there is no amicable solution within the team. In this situation, unfortunately, the lead, instead of the DDPP, was the ID. So she would then take the ultimate decision on how the matter would proceed. So she would then overrule the opinions of junior prosecutors like Advocate Ramsamy to say this is how I want it to go. I agree with Chief Perumal or whatever the case. So that is how in this specific matter it is.
So the head of investigation included from all of that. You don't play a part at all.
That decision making is that of the ID. I would not be included in that. We can have a discussion, but ultimately this is how it's going to and it would happen.
But you did participate sort of in the lead up to the final decision about what you mediated this meeting, and then you indicated that there were several other meetings to talk either.
Yes, as I said, that it would sort of be a complaint session. Chief Perumal come to me to complain. Advocate Ramsamy has made a submission that there is no case and all that, and he believes there's a case. Those kind of things. So when we discuss these matters and trying to find out where the fault line lies, you have people who've got strong opinions about this, and the ID would then take it to say, this is how it must be done, and ultimately will be done that. So that is why decision to proceed the way these matters were proceeded with, decision to enroll, all these matters were done by.
We can then proceed to the next, which is the disciplinary and legal matter concerning Mr. Rapet. That's at paragraph 47 of your application.
The last occasion on which I was involved arose when the ID convened a meeting and informed us that she had received a call from Mr. Ngabinde. Mr. Ngabinde alleged that Mr. Rapesu had telephoned telephoned him and informed him that IDAC was conducting an investigation against him and that Mr. Brian Bridgette was there. In other words, Mr. Rapeso had leaked information to Mr. Nkabinde. Present at the meeting were me, Chief Perumal, Mr. Rapeso, and Mr. Rapeso. Mr. Rapeso denied that he had called Mr. Nkabinde. He posed to an affidavit confirming that he never done so and offered his cell phone and to take a polygraph test to demonstrate his innocence. I was tasked by the ID to refer the matter to our security management SMS to arrange. The SMS began the process by referring the request to but then reverted to us to say the security agents does not conduct polygraph tests in internal disciplinary matters, and that if IDAC wished to have one conducted, it would have to procure the service itself. That was never achieved, and the matter was left there. Mr. Rapeso continued to ask about progress, and I gave him what I knew through his supervisor. I was later told that he had lodged the grievance about the issue. I subsequently learned that the grievance had been dismissed on the grounds of a time lapse. At the time I was asked to facilitate the polygraph, I received a report from one of our investigators, Mr. Ndumalo, who had been tasked to investigate the alleged. The report recorded that Mr. Nkabinde was refusing to provide a sworn statement about the alleged. The ID wrote a letter to Mr. Nkabinde calling on him to provide a statement, and if he's not willing, indicate so in writing. Attached is a letter from the ID marked MS. Mr. Nkabinde responded to the ID letter with the email dated 27 March 2025. The email is attached as MS7. The ID further wrote to the advisor to the minister, Advocate Pikoli, raising frustration about Mr. Nkabinde's failure to provide a statement. The letter is attached as MS. Mr. Mbalo expressed that Mr. Rapeso would have leaked the information. Alternatively, that Mr. Binang would have done so, allegedly because he learned that I revealed information to Mr. Binang. Attached is a report by Mr. Mbalo marked MS9. On my reading of the report, I was convinced that it insinuated that I'm also a suspect for leaking the information. So when communicating with SMS, I advised them that I was also volunteering rejected to polygraph test based on paragraph 4.2 of the findings of the report. Attached the email dated 25 June 2025 to SMS marked MS10 communicating same. The obvious difficulty with that report is that the allegation was that ID herself received the call from. There's no indication in the report that a statement was obtained from the ID about the allegation and to obtain the records of the alleged call to her, nor were the records of Mr. Rapeso, Mr. Binang, or me obtained. I recently learned a further step that I regard as a review. While I was on sick leave in January 22, an investigation was authorized within IDAC in terms of Section 2813 of the NPA Act against Mr. Rapeso for leak. The authorization was for the contravention of Section 41(6) of the NPA. The application memo indicates that it is from Chief Peruma, even though his signature is not in the memo, and it is authorized by the ID. Attached marked MS11 is the application authorization. This offense is definitely not with the IDAC mandate and should not have been authorized in IDAC. I regard this as odd for 4 reasons. First, Section 41(6) investigation of this kind is not an IDAC mandate. Second, the ID herself received the initial complaint from Mr. Nkabinde would appear to be conflicted in authorizing an investigation arising.
She's actually the complainant because Nkabinde is not the complainant.
Yes.
So in a 41(6), the ID is complaining.
Yes. So that's why I'm raising that. Third, Chief Perumal, as a witness in the investigation, cannot apply for authorization. Fourth, maybe to explain this, when the ID called that, she indicated that when she received the call, she was with Chief Perumal and Chief Investigator Padiachi. So they had that call or the conversation between her and Nkabinde, which makes them witnesses in this. So that's why I'm saying that Chief Perumal as a witness in that she cannot apply for the authorization. Fourth,
Had the ID a call on speaker, or how would?
Yes, that's what she indicated. Fourth, there is no indication that the former IPID officials who are alleged to have attended a meeting with me were approached for their statement. When I returned from leave, Chief Perumal briefed me on the referrals he had dealt with in my absence. So those referrals are those that will be on MS5 that he had dealt with, but he did not mention this one. As I was preparing my affidavit for the commission, I called the IO, Mr. Mbalo, to inquire about this matter. He confirmed that the investigation was authorized and that he was going to recommend that the investigation be closed as there is no evidence to implicate Mr. Rapeso in wrongdoing. I called for the file and established that there is a statement from Mr. Nkabinde dated 27 November 2025. Mr. Nkabinde, who had refused to provide a statement, now deposed to an affidavit which expanded the allegation to implicate me, asserting in substance that on learning of his appointment as Chief of Staff, I had convened a meeting and asked investigators to investigate him and to find anything they could against. I deny that allegation. Mr. Nkabinde's statement is attached and marked MS12. What I find odd is that the colleagues who are alleged to have been in a meeting with me are not approached for their statement to corroborate this allegation. I also established that only a subpoena for the cell phone records of Mr. Nkabinde and Rapeso were requested. They were analyzed by Digital Forensics South Africa, and their report confirmed that there is no record of the calls either from Mr. Rapeso's phone or Mr. Nkabinde's phone. No cell phone records were obtained for the ID phone to confirm that the call was made to her.
Thank you. I think we can then move on to the next section, why I did not impose myself into these matters.
I've been asked why, given my position and the leadership role I ordinarily play, I did not raise concerns at the time or ask to be included in this matter. The answer lies partly in my own history. During my time at IP, I was involved in serious conflict. I stood my ground and I paid a heavy price for it. I was suspended in 2015 and subjected to a disciplinary process and criminally charged, which I regarded as unlawful. The charges related to IPID report concerning the rendition of Zimbabwe. In August 2016, I was dismissed in absentia after found guilty of gross misconduct at a time when I was hospitalized for depression. My request for a postponement had refused, and I never gave evidence in my own defense. Following the Constitutional Court finding that the suspension of the then Executive Director, Mr. McBride, was unlawful, he was reinstated with possession. I also challenged my dismissal through the Bargaining Council and was reinstated. I was suspended again in March 2020 by an incoming acting head of IPID, and again had approached the Bargaining Council. I was then reinstated. I testified before the Zondo Commission about police corruption and about political interference that I believe lay behind my suspension. These experiences were costly personally and financially, and to my family. I'm 61 years old, near the end of my career. When I found myself excluded from the CI matters, I made a deliberate decision not to force my way. I took the view that if the ID did not involve me, it was not because he did not want me involved. No, it was because he did not want me involved, and I respected. There is in any event a practice at IDAC that if one is not on a matter, one does not seek to know it, and there is a related principle of neutrality. I let the matter be, and I did not ask ID why he did not involve me. There was also a further, more recent consideration. On the 7th November 2025, I was kidnapped while driving home. I was assaulted and robbed. My attackers took my state-issued laptop, cell phones, and abandoned me near Rugby in the early hours of the 8th November. I reported the matter to the police and received medical treatment. While I cannot say with certainty if this event is related to my work, however, there were two distinct occurrences during the robbery that makes. First, the kidnappers demanded a firearm. When I told them I did not have one, they assaulted me so much as if they knew I should have one. Second, when they took all the gadgets, laptop, cell phone, tablets, Samsung watch, they asked for PIN numbers and passwords of all these gadgets. However, on the work laptop, they specifically demanded that I write the password on one of the campus phones, and they took the laptop to a house. They only did this with the laptop. This occurred against a backdrop of public allegations against IDAC and its leadership, and of threats directed at the unit following the CIR. That experience had affected how I approach my work and my own. In the circumstances, rather than insert myself into these matters from which I had been excluded, I confined myself to assisting on discrete issues on which I was asked to assist, and to advising those members of the team who approached me for guidance. I otherwise left the ID, the head of the unit supervisor, to deal with these matters as she saw fit. I wish to make one matter clear. I do not say that there was no case to be investigated against CI officials. My concern is not with whether there was a case, but with the manner in which these matters were handled, and in particular with a departure from the established intake. Even where there is a case to answer, it must be dealt with in accordance with the process, and where the process is not followed, the integrity of the outcome is placed.
Before you go to you play any part in IDAC before the ad hoc?
No, I did not.
Because when the former ID went there, she was not going there in an individual capacity. She was going there in IDAC. So you are head of operations at IDAC. Do not assist at all?
Not at all.
And then after the 6 July 25 conference, media conference by General Mkhwana, serious allegations, I'm sure you are aware of.
That's correct.
Do you not, as head of operations, look within? There's nothing wrong that IDAC did, so that you can assist the IDs to account Parliament?
There were meetings and discussions about those revelations by General Mkhwana, and in those meetings they were dismissed as a counter to the investigation that had happened at CIG.
And then internally, Advocate Serunya raised issues. One was referral affidavit was not there. The investigators did not have. So that was the one. The second issue was the two CI matters, the Mokwele matter and the Lushaba matter. They were not he raised those serious concerns. And as far as I understand, you were copied in that. Why did you not do anything? He says the 67 is not there, has not been provided. And second, these investigations were supposed to be they were being led by junior advocate at IDAC. Did you not say anything? Did you not intervene? Did you not raise the bill with the ID? Did you just let those slide?
My recollection is that there were engagements about and with the ID and also at Advocate Serumi. And the ID was not even happy about those things being raised, because as I understood at the time, she felt that these matters were properly within IDAC. And I think she sort of took umbrage why those issues were raised. So in those meetings, I think the issue was, a decision has been taken, matter is authorized, it's going to proceed as.
And then the last one, your investigators, Mr. Padiaki, the Chief Perumal, been accused of what on the face of it is serious serious misconduct that may well amount to fraud. The Commission has not made findings one way or the other because we must hear all sides. But the allegations are that they created affidavit many months after, and then they backdate the affidavit to create the impression that those affidavits were deposed on the 6th of January 2025 in relation to Mr. Adams' supplementary affidavit. And then in relation to the Section 77 affidavit, the allegation is that the affidavit that had been provided to Commission and the one that we commissioners are looking at was only created after October 2025, and it could not have existed in November 24 when Mr. Adams made referral to IDAC. Now you as head of operation, when you hear allegations like those, you make inquiries internally to find out and if the Commission has misled and has been provided fraudulent documents.
Chair, my recollection, I heard of the allegation when these matters were being. I think Mr. Rapis would have indicated that he suspects there is something wrong that would have happened with the Section 27. And if I remember, his ways was, but the truth will come out. So I remember speaking with Chief Perumal, if he knows anything about it. And then he says, no, there's nothing. Everything is on board. And I took his word.
And it's a question Chair asked, because you are the head of investigation. Is it common, is it usual within IDAC that an investigator start an investigation and conclude the investigation without having seen the referral? Because Mr. Padiaki told us that that's what happened. He never saw.
Chair, in terms of our process, and the manual also looks to that, when a matter is authorized and the project manager convenes a project meeting with all stakeholders, including the DDP, all information relating to that matter is shared and discussed. It is an anomaly for those documents not to be shared with. It is clear that on this matter, there was exception to the rule.
It also have formed part of the application for a warrant of arrest, the 27 affidavit. So when IDAC applies for a warrant, should the Section 27 have been attached to the affidavit that was before the court? How does it work in practice?
In practice, the investigating officer will draft an affidavit, basically outlining the investigation conducted and the offence that alleged to have been taken.
Sorry, because the starting point is referral, does he attach it to the affidavit?
No, in practice it's not. In practice.
But it forms part of the document.
In practice it's not.
So in practice it does not form part of the document. You don't even share it with the accused.
No, it is part of correspondence, internal correspondence, but it's not attached to the document.
And when they ask for it because they want to challenge IDAC's or IDAC's mandate, how do you?
Well, when they ask for it, in my experience, is that it when they had asked.
So, Sesoko, when a docket is opened or when an inquiry is, doesn't the Section 27 become the A1 stage and then it can be supplemented further to add to the affidavit? How does it work, the start of the investigation? Assume that the investigation has been authorized, either in 1 or 30, and then a docket or an inquiry. Shouldn't the section affidavit be the A1?
In practice, Chair and Commissioners, the Section 27 referral is treated differently. When an investigation starts, when it's authorized, then the complainant is approached for an A1 and a full comprehensive A1 statement, which would address all the elements of the offense is then open. And that is what is used as not the section.
Where does one find that? Is that in the manual or is it your
It's the practice.
But where does one find that? Where is it recorded that that's the practice?
I'm not sure if we record it like that in the manual. I must be honest. I'm not sure if we do that. I think the manual states the processes that must be followed, but it does not specifically say what happens in relation to Section 27 or an A1 statement, because it's more of an investigative operational issue that it has to.
And the reason we are asked because Mr. Serunia Peter and Ms. Rems, they have testified in this commune that, and I hope I'm not confusing the transcript will bear that out, but they said the Section 27 affidavit becomes the A1 statement, and then any further statement obtained from a supplement the section. So the Section 27 is not eternal doc, is the genesis of is the affidavit that must set out what offense reported and what offense must be investigated, so that what the investigator looks at and what guides the investigating officer, in fact, that affidavit.
I won't dispute that it may happen in other matters, that, the Section 27 included as an A1, But I'm talking in generality what I know would have happened in most of them.
But because IDAC has not had that since you said so, you'll most are from, and there was that general from the former IDAC. Don't you something clarified?
Yes, certainly, Chair. I mean, this experience with the Commission, it's a lot of lessons learned for us. We already having a discussion internally about IDAC reset and how we improve our operation and including our manual, so that we are all clear in terms of processes, because this process has shown the weaknesses within the organization that really need urgent attention.
Weaknesses are serious, systematic.
It is
they
true.
Can impact not just IDAC but other law enforcement.
That is true, Commissioner. lessons learned.
Can I just, you say in paragraph 59 that there is a practice in IDAC that if you are not involved in a matter, you don't seek to know its detail, and this relates to the principle of being neutral. But surely that position in practice does not apply to the ID.
Yes, it does. It does not, Commissioner. She's the ultimate person that on all these matters. A matter cannot be enrolled without her approving. So every decision of this nature, it is taken by the ID.
But then by same, well, not same, you are head of investigation. It seems to me you should know what's happening in investigation.
Yes.
So that rule, if it's a rule in the workplace, should not be applying to head of investigation, because you need to be able to speak to the investigations that are happening in your organization.
That is correct, Commissioner. And in most matters, that's what,
Yes.
as I said, this was.
So in a properly working IDAC, a person in your position who is head of investigation is supposed to know, involved with investigation. When I say involved, I don't mean you run and do the investigations,
Yes.
but you, because you're the overseer
Yes.
of all the investigations, so you should know that.
That is correct.
Therefore, it must mean I'm trying to determine whether is this a person problem that you ended up in this position where you don't know about investigations that are happening because they're being directed by the ID who chooses Mr. Perumal, Mr. Parachi, and others. Is it a problem that a different head of investigation would have been correct to say, I'm head of investigations and I will not be excluded from investigation? Or it's a misunderstanding of your role by both you and the ID, that you are also subject to that rule of practice, that you don't need to know what's happening in matters. I think, put simply, is this a structural problem? Is it we happen to have the wrong people in the positions. We had the wrong ID in the form of Ms. Johnson, who did things the way that she did and excluded, or we had a wrong head of investigations who didn't accept his role and position when he gets excluded. Can you just say which one it is? And the question is important because, at least from where I'm sitting, because among the things that we have, the Commission is required, is to make recommendations, including recommendations about what changes need to be done to the organization. So we are going to have to grapple with how did IDAC land where it is today? Is it a structural problem? Is it that whoever employed Ms. Johnson has made a bad decision? Whoever employed Mr. Sesoko made a bad decision? You understand what I'm asking you? Can you just comment to that?
Chair, the fact of the matter is, in this particular instance, rules were not followed. And I took a decision at that point in time, as I explained in my affidavit, based on my personal history. I take full responsibility that I should have acted differently, but at the time, for me, it was the right to take, given the considerations that I've said.
I understand, and thank you for that answer. It's trying to understand whether, what's behind my question, whether in terms of your contract of employment, which sets out what your job, you could have asserted to the ID she didn't like, you could have said, there is no investigation that will happen that I don't know anything about. Does your contract, in terms of your contract, you that kind of standing, or the problem in the contract, because maybe she still gets to make decisions finally about investigations. I'm trying to understand that. So I'm trying not to make it personal to you, but to understand what are the limitations other than your personal second. Another head of investigations, will they not find themselves in exactly the same position for different...
Perhaps to add to that, besides the contract of employment itself, or in addition to that contract, there are the annual performance, what do you call them, which you sign with your boss, undertaking that you are going to perform in accordance with, and then, as I understand it, this itemization of all of everything that you undertake, you are going to do during that year. Am I correct that there is such a thing? What is it called?
That is correct. The performance.
Yes. Now, I'm adding to what Commissioner Baloyi says with reference to the employment contract itself, and I'm saying there's also this performance. Would what you are required to do not also be, it would obviously be included in that, and would it cover what Commissioner Baloyi, if it would, what would you be assessed on if not on that? That is what it covers, which includes the issues that Commissioner Baloyi has raised. At the end of the year, how do you get assessed if you've not said, now if you do not allow me to do A, B, C, D, how am I going to be assessed at the end of the year? So basically, that contract would require of you to raise the issues that Commissioner is referring. Now, can you please respond, with all of that in mind, can you please respond to Commissioner Baloyi's question?
Thanks. My performance agreement provides that I must advise the ID. As I've indicated that these matters were discussed and should take up. I understand the concerns, and in hindsight, maybe I should have taken to even further and not let it be as I did. But that's what, to me, at that point in time, seemed right. As I said, that maybe I should have acted differently by raising this issue at a higher level, so that what now has been ventilated here could have been stopped. I'm not sure if it would have made any difference.
Sorry, you may carry on?
No, I was saying that I'm not sure, however, if it would have made any.
You say you're not sure because the ID is the person that she was or what? Because you see, you say your contract says you advise the ID. Next question is, well, what does that mean in fact? You advise her on investigations that your people are doing and what they put together before she makes a decision. Does advising mean that you say to her, on this investigation, there's no case? She ultimately, gets to sign off on the next steps. But what does advising her entail?
Advising the ID, it means advising her on all operational where matters are under investigation, what are the challenges, what needs to be done. Most of the time, what happens in practice is that decisions like enrollment and so forth would happen when there has been a meeting of all stakeholders to discuss that matter, and when there is a consensus that the matter must be enrolled. But my advisory role is where there are issues of that affect the projects, so that we can discuss how we overcome them. In relation, for instance, to these specific issues that are raised here at the Commission, there would have been discussions about it to say there are issues that have been raised. There is concerns about this, and she would give that direction to say, no, I'm satisfied about this. This matter will go on. If there has to be a takedown, the takedown must go on.
You see, from the evidence, say, let's take the Mukwele matter, that it has appearances. Even we haven't made any final decisions, but concessions made by the witnesses. There seems from those concessions to be an accept that there were shortcomings in the investigations. At least one area, there were shortcomings in the investigation. The question that it prompts for me is, where was the head of when there were these bad shortcomings, these serious shortcomings, and the matter gets J50 issued, people get arrested and they go to court. Where was the head of investigation when this happened? Where a poorly investigated case lands at people getting arrested and people getting to court. Even before that, it lands at a decision to prosecute. Now, from your answer, it's still not clear to me that things got that bad because the head of investigation was missing in action for reasons that or look at the perimeters of my powers, my position. I can't do more than forget that I didn't tell the ID maybe, but if you look at my contract, I can't do more than just saying, ID, this investigation is poor, the matter is not ready to go to court. In the end, she makes the decision, because if that is the case, it may well be that recommendations or thought must be true. How do you give the head of investigation more power, or ensure that in their contract they get to make determinations about investigation, and they're the ones that sign off to the ID to say, yes, I'm happy with the investigation, and until there is that sign off, the ID may not approve, may not give a decision, or may not sign off. I'm trying to get you, to assist us in answering that kind of question. And I must say that in your answer, the way you've answered, I haven't gotten assistance for the answer to me.
I understand, Commissioner. The reality of the matter is that this investigation was directed from the ID, not from my office. All decisions relating to were directed from that office, including the takedown. I learned of it after the fact. When, in normal circumstances, when you conduct a takedown, we sit in a meeting, discuss how that takedown would look like, whether there's a warrant of arrest applied for or HK175, all those. That was not the case in this case. So it was an unusual situation, and I think that's the best way I can answer you.
Would you consider as an appropriate suggestion that I put to you, that the system, the structure has to be such that the ID should not be immersed in the investigations, should not be directing investigations, because ultimately her people must satisfy her when she make him her. When they make the decision now, as they're empowered to do, starting with the 2813, right? 2813, the ID should be sitting as a neutral party, so to speak, where others come and persuade her, we need a 2013, and then she can interrogate what they're doing at that point, and then they go and do their work. Now she must authorize an investigation. She should not have been involved in the process of directing, go find this, go find that, because ultimately when they come to her, to her in this case, because it was a her, for a 28-1, she must look at it with a fresh eye, with an unbiased eye, if you like. The same for all the various stages that she must authorize. Would you consider it an appropriate suggestion that the ID should in fact be insulated from all of that, so that by the time she's required to exercise the statutory powers of being the ultimate decision maker on the different steps, she looks at things with a new eye and an unaffected?
Commissioner, I agree totally. In fact, most of our matters, that's how they have been conducted. She would come at a very tail end. And as I said, that when those meetings are discussed, where now the team says the matter, the investigation is complete, now we're ready to enroll. And that's how in most matters it would have happened, except
Maybe the exception suggests that it should be an entrenched position in
Yes.
respect of which no ID is an option to deviate, and there's no exceptional matters because all matters that to IDAC must meet the criteria. They cannot be exceptional and sensitive. That only the ID.
that is correct, Commissioner. And that's what motivated me to create the case.
Part of the concern you have raised, or an explanation that you have for not escalating things to the end, you shrugged your shoulders. We've had evidence as well that where matters have been escalated to the end, then there was no good outcome out of it, and people seem to have ended up in worse position before they lodged the complaint. How do you suggest to fix for that? Is it again a matter of, well, it's about the integrity of people that you appoint, or problem this scheme that we have where you have IDAC falling under the NPA and ultimately the NDPP, the one that people must escalate things, but the NDPP has a working relationship with the ID because they all belong the same. Is that the problem? And does, in your view, the appointment of the judge, IDAC judge, and whatever his terms of reference are, create a different playing field than what you had when you ID?
Commissioners, I think, unfortunately, the issue of the judge came much, even though it was provided for in the legislation, I think, time to be implemented. I would venture to say that had it been in place much earlier, some of these issues would have been raised with the office of the judge, and maybe there would have been intervention much earlier.
Do you say that because the terms of reference of the judge?
Yes. Remember, the judge would look at complaints, even by IDAC staff, political interference, whatever complaints they might have in relation to how IDAC is run, and of course, even public about the work of IDAC. So I think people would have felt even more empowered in the matters of IDAC.
Thank you.
We are left with only subject that we left with.
Chair, perhaps can the witness read that, if any? Sorry, the look that you gave, I wasn't sure.
No,
But
no,
what?
please don't. I don't want to mention the council name, but don't play that one.
No, man.
He always tries. He always tries to read my face and make conclusions.
No, I withdraw the remark, Chair. That perhaps what will remain will be a couple of clarities and some questions of the aspects of other witnesses.
Thank you, Ms. Bowie. Can you please conclude reading yours?
Thanks, Chair. I consider it important that the Commission should not conclude that IDAC is, as an institution, compromised. IDAC has sound structures, capable and committed people, and good process. There is a lot of work that has been done by IDAC colleagues at IDAC, which shows how committed they are to the fight against corruption.
You left out good. There is a lot of good work.
There's a lot of good work that has been done by colleagues at IDAC, which shows how committed they are to the fight against corruption. I would like to refer the Commission to the infographic marked Annex MS-13, which gives a summary of matters dealt with by IDAC as they relate to state. My evidence concerns the manner in which a particular set of matters was handled, which in my view was an outlier and not the institution as a whole. For the reasons set out above, I recommend that the intake and selection process contained in the operational manual and case selection criteria be fully operationalized, including a single designated intake point and case intake committee. That process was designed precisely to guard against difficulties that have arisen, to ensure that case selection is objective, auditable, defensible, and to insulate the ID from allegations of targeting or selecting case without proper pay. Had this been operationalized, many of the concerns I have described would have been avoided. I make this statement in order to place my account of matters and of IDAC process before the...
Sesoko, there in paragraph 66, you talk about operationalizing the manual. Don't you need more than just operationalizing it? Because that's quite a soft position to take, and it's still subject to human conduct. You can get another ID who simply ignores it. Isn't the solution that it becomes part of the set of documents which are policies and protocols, and if you don't comply, there will be consequences? Because as matters stand, I understood from an earlier discussion that there doesn't seem to be any repercussions for non-compliance with the manual. But if you do have repercussions, disciplinary action, it doesn't necessarily have criminal prosecution, but you treat it as part of a policy documents or protocols, whatever name you give it, and it's clear you don't comply. Isn't that a position you should be advocating for?
I would agree, Commissioner, that yes. I think the manual as it stands is not strong enough in that area in terms of consequence. And I think already, as I said, that there are discussions about it, that there must be movement to it so that everyone complies with its provision without it.
And there's consequence.
And there's consequence.
If you don't comply.
Yes.
And then lastly from me, in paragraph 5, you say my evidence at the end, you say my evidence concerns the manner in which a particular set of matters was handled, which in my view was an outlier and institution as a whole. I must confess that I'm outside IDAC, but the bit that we have had from I would be very cautious, and I think I would suggest you are too, being inside the investigation, about how far this call an outlier go. We have become aware of crime matters because General Mkhwana's held a media resulted inquiry. The question that I would ask is, well, how far does this go? What else are you not aware of? For example, you haven't spoken to what Mr. Rapp testified to, that there's an investigation about a 50 million rand that was supposed to be taken by General Lushaba. He says, when he called you about it, you didn't know anything about it. So you do have an idea of what's happening, but maybe in fact the reset that IDAC is doing should include a real deep inquiry into how far does go. What else was being investigated? Because that's a question that I asked myself as a commissioner, that we've had evidence here, but what else was being investigated off the books that you will not find on record? My suggestion would be cautious about, well, what we know is the outlier means worse than that. And until you've satisfied yourselves that this is all the words that's come out of a mission, more cautious. I think there is cause to be concerned. How bad is all we have seen, and that's the end of it. I have no reason here to think that's all.
And I understand, Commissioner, from your own position. I'm speaking from what I understand. As I said, that there are 157 matters representing 88% of our work, which I believe may not be tainted by this. So my statement of an outlier stems. It doesn't take away the fact that we have to review. There's an agreement within the organization that we have to review all our matters and be sure that there is nothing and if there's injustice that would have happened, it's corrected. That's the position of the NDPP, that's the position of the...
Mr. Sesoko, before this last engagement by Commissioner Baloyi, my co-commissioner engaged you on what you consider to, and there was a discussion on policies and how strong the wording of that, in particular with regard to consequence. I just want your comment on this. I have no idea what we will recommend in the end. It may either be a continuation of an institution called IDAC, or it may be a totally different institution. I do not know, or the killing of any such institution altogether. But on the assumption that something similar to IDAC, where depending on the acceptance of our recommendations continue to exist, don't you think it would be better if the processes would actually get legal force from an act, whether it's the NPA Act or whatever other act? So the act itself specifically provides that such process document should be created, and having its force from an act of parliament, it would be less likely that it would be flouted at whim or at will by whoever the head. Of course, human beings being what they are, they will flout laws, which is why, for example, we have criminal trials at the time. We have administrative challenges against state functionaries, and so they will flout the law. But I think it will give more force to have it provided by the Act and not officials sitting down crafting their own document as they please and of their own accord. What's your comment?
Chair, my comment is that I think it will be a good idea that IDAC will have operation. In my previous environment in IP, that's what we once, because I was involved in the development of that Act. But we ensured that there are also regulating the operation. So once they have a force of regulation, then it enforces all this.
And is it the Act itself that says there must be
a regulation?
All right.
Which talks to...
It's exactly something similar that I have in mind.
Yes.
Depending, of course, as I say, on what our ultimate requirements are to IDAC.
Yeah, I assume we agreed that
the lunch.
take the lunch.
And let's adjourn and come back at 2:15. Let's adjourn.
1-2. Good afternoon. It's 2:15. We are ready to resume. Please make sure that all your devices are quiet and silent. Thank you.
Yes, Ms. Bowe.
Thank you, Chair. Mr. Sesoko, there's a couple of issues that I wanted us to go back to in your statement, and I'll try to do so thematically so we can move. The first is short, and it relates to your annexure MS01. Just to note, Commissioners, that there was a mistake with the labeling of annexures, and there I take full responsibility. You'll see it starts with MS01, and then the next is MS1. We propose to leave it like that. Alternatively, we'll go 1.1. But for now, if we can turn to MS01, and it's just a clarity question regarding this document. This document seems to be discussing the secondment of investigators from IPED to the ID, correct?
That's correct.
When regard is had to it, I think it then lists the individuals to be seconded.
That's correct.
And then one of the annexures to it is that list of cases that's attached as Annexure G to this. What we wanted to understand is, as far as the dockets themselves and movement of those dockets from IPID to the ID or IDAC now is, what informed that? Because this largely just speaks about the secondment of the investigator.
Chairperson and Commissioners, my understanding of MS01 is that it records the correspondence between the former ID and the then acting executive director or directors, acting executive directors, both Mr. Sinne and Mr. Sitsedi. But it records all other discussions that happened, including the issue of of the handover of the docket. At the time when this happened, I was in IPIC. It was before my secondment to IDAC or IDAC.
So you weren't involved in deliberations?
Yes. So the deliberations happened between the acting head and the head of ID at the time, Advocate Cronje. My understanding is that, as I testified earlier, that upon the proclamation by the president of ID, when the ID then, which is IDAC now, started operating, the first thing that the investigating director at the time, Advocate Cronje, did was to write letters to DPCI and to IP to request the handover of all the dockets that were related to state capture matters, that were related to Mbati and Lt-Gen as per the program, but also requested the investigators who were working on these matters, because the ID at the time did not have its own resources. So they relied on secondment, or as the TPCI called it, duty reassignment of these investigators to the ID. And that is how all these matters landed in ID. So there were a number of cases that were opened when there was a lot of discussion about the state capture and the Guptas. There were a lot of dockets that were opened by civil society, by politicians, and so forth. So once the ID was established, then Advocate Cronje asked for all those matters, as long as they traversed the issues that were being traversed on to come to the ID. Now that list came as a result of matters that were in IPIT and were dealt with at Zondo.
Are those the only case that came over, that were traversed, that raised issues, also touched upon? And when you say facts that relate to these dockets that are now in IPIT, the same facts arose in Zondo's or come to state capture. Is that what you mean, they traversed?
Yes, Commissioner. So, as I understand it, the investigating director at the time authorized, in relation to what they called security sect at that time, matters, authorized all matters that related to the testimony of Robert McBride at the Zondo Committee, but as well as all alleged procurement corruption that is alleged to have happened within the SAPS and CI and the state security. So it was sort of an all-encompassing authorization.
Thank you, Mr. Sesoko. Then can we move on to deal with your involvement in the CI-related matter? Now, in your statement, the first incident or the first occasion of your involvement, you note of December, the first time, and this is when Mr. Rapid calls you. Is that correct?
That is correct.
And you then say that he called you asking assistance to General Jakes regarding handing over docket.
That is correct.
In your testimony earlier, you indicated that you did not know anything about the investigation, and what you did was assume that it was authorized.
That is correct.
Why did you make that assumption and not before making a call?
Person, I think, as I said earlier, that I wouldn't expect an investigator to ask for or give Perumal to instruct someone to ask for a docket from the SAPS if a matter is not authorized in. So that is why I had assumed that it must be authorized.
On your testimony, you said that there had been 2 occasions where were authorized the ID's office, and you then find out about them, as a by the or after the fact. In this instance, you would have known nothing. You were requested, or you were going to call a general to hand over docket of live investigation, and you did nothing by way of verifying. Which means if Mr. Rapisu, for example, was out on a limb, not seized with an action, you would have participated in acquiring dockets, as that really wasn't authorized. I guess I'm trying to understand why you took a massive step, because it's not like you're speaking to General, the head of IG, and asking him to hand over dockets, where in a matter you know absolutely nothing about.
That is true. I in retrospect, maybe I should have asked first, but I think it's also a trust. I didn't expect that an investigator would ask for a docket without any authorization.
Can I just ask something about this? Your answer for me would hold if at this point you were aware that there is an investigation that is being conducted. And so when Rapesu calls, you would, I think, reasonably assume, of course, I know about this. Not as would say, of course, I know about it. And then reasonably assume that he's asking because and sent by to doubt that. I can understand on facts. You didn't know as of December 24 that something is happening done related to crime, and then you have a junior, I call him a junior, only to say he's not the chief investigator. He calls you and facilitates this. You didn't know what he's telling you at that point. Perumal is conducted, you know nothing about. And at this point, Chief Perumal reports to you. So if you didn't know, it doesn't make sense. It is curious, in the absence of an explanation, that you don't call Perumal and say, what is this that I hear about? Before I do anything to get dockets released, I'm your boss, you report to me. And then have Perumal tell you it's in the ID's office. And then maybe at that point you say, oh well, in that case, I will have fear. That would make sense. As I say, the alternative, you knew something was happening, and that's why, and that you've been excluded, and that's why you respond to Rapesu. Can you just explain?
Commissioners, I think my actions at the time were mainly based also on my discussion with Rapesu, and in terms of how the instruction came and so forth. But I also took a view that I will take it up with Chief Perumal. which I said. But at that point in time, I must admit, I did not call him immediately. I'm not quite sure, commissioners, it's quite a while. I think we might have spoken much later on that day with Peruma.
But you would probably have actioned already by the later in the day. The question really, before you act on something like this, and we've had evidence that says actually Andrea was very busy. People were very busy. That's the day that I think Section 13 was issued. Clearly, lots of activity. And unless you were not in the office, it's difficult to understand that you would not have been aware, even if you are not involved, but that you were completely unaware that this is brewing, this is happening. And then, firstly, that you were not aware at all. Second in command, people report, and then Rapesu calls you, and you deal with so compliantly on your statement. Obviously, he calls you because he thinks you know something about this, you're involved with this, you're the head of investigation, and then you are compliant, facilitate without asking any question. I don't understand. And what makes sense to me, and let me put it to you so that you can comment, what makes sense to me, at the 6th of December when Rapesu calls you, you had an idea, you must have had an idea of what you may have you may have decided to distance yourself from it for reasons that you've given in any other reason. But the picture that this creates, you must have been aware that something about crime intelligence going on. And I'll just do what they ask me to do. And
Commissioner, if that was the case, I would have considered. As I said, and I think even Mr. Rapesu would have testified to the fact that when he spoke to me, he realized that I wasn't aware of it. So I wasn't aware of it. Yes, I did facilitate. And in fact, if my memory serves me well, at the time when I spoke with General Jacobs, because that date was on a Friday, and General Jacobs would have indicated that he must come on a Monday, Mr. Rapesu. So my thinking at the time was that I will then follow up with Chief Peruma.
thank you.
And if we can then move on chronologically about what happened. You then speak about the meeting that was convened by the ID and the report to Minister of Peace. To deal with that one, I'm going to ask that you look at file 10 at page 251. Maybe just to introduce the document itself. This is an affidavit by Ms. Ramsamy that she says the purpose of it was to deal with the events. This was around when Mr. Rapesu was being charged with having leaked information. And so she did an affidavit about what she knew surrounding those events. And it was commissioned, I think, on the 3rd of March. Oh, my apologies, it's dated 1 April 2025. Now, if we can then go to paragraph 6.18, you'll see there, I don't propose to read the entire paragraph, but if you look at the last sentence, I realize the whole paragraph might be the sentence. So it just says, on 16 January 2025, there was a scheduled meeting with a Deputy Director, Senior Investigator Binang, and myself in the ID's office on another matter. After that meeting was concluded, I asked the ID if I may see her privately on another matter. The other parties were excused. I then asked the ID if the designation had been extended to Lt-Gen for diversion, and I explained why. As per paragraph 6.16, I expressed my concern after the ID informed me that she was not aware that Lt-Gen was party to that consultation. The ID then sent an email to all designated members and the head of operations, Mr. Sesoko, for a presentation to take place on the 22nd of January 2025, and I was told to note my concerns in the presentation. Do you recall an email of this nature from the ID?
No, Chair, I can't particularly recall. As I said in that, there were a number of things that were called. Some of remember the contents thereof, but it's possible that there was such a...
Yes, and this meeting, the one that happens on the 22nd, is the one that you are referencing at paragraph 36 of your statement. You'll recall in your testimony you confirmed that you suspect that this would have been meeting of the...
Yes.
Now, the day before that meeting, Advocate Ransamy then emails the presentation, and for that we need to go to page 216 in the same file 10. Do you have it?
Yes.
You'll see there that Ms. Ramsamy on the 19th of January at 12:04 emails to you and the ID the presentation and in the body of the email it says, my apologies for emailing over the weekend. The presentation is due tomorrow and the team are engaged in various tasks attached for your perusal. So in this instance, you weren't copied. This was sent to this presentation. Do you recall if you read it prior to the...
I cannot particularly recall, but obviously if it was sent, I would have looked at and it probably was part of a meeting.
Okay. And in instances where you were sent these kind of presentations regarding this would be the plan for what is termed Operation Diversion, what is your role in those circumstances?
Well, normally you expect that there will be a presentation by on the matter that is dated, whether there are things that have taken in or not. And if it's called by the ID, it's normally because the ID wants to take direction in that.
When you say the ID would give specific directions, in this meeting, are you also not engaged in these types of...
No, there will be engagement by everyone.
So you'll be an active participant?
Yes, everyone will participate. But normally it will be the team itself. So the team will present and say what their views is about the case, where they are about the case. And if there are issues that we as management want to raise into that, then we'll raise those. If there are issues of concern that are raised there, they will be discussed, and then there will be then a decision of how to move forward.
So your role is to be there as management and to deal with issues that arise in things?
Yes.
And then so, because this was sent to you in preparation of this meeting, you would have read, so by this date, you would know of this option, David. You would now know.
Yes, now.
Now let's go into the presentation.
You go to the, can I say, Mr. Sesoko, that this email of the 19th of January is addressed to you and the ID, but in fact is preceded by an instruction by the ID that you should also be emailed about the presentation. What it suggests is that at this point, the ID had not from this matter covered in presentation at least. She had not, otherwise she may well have taken the matter. It's an ID matter, described it without going the manual with you matter on. But as of the 19th of January 25, she quite clearly, and in fairness to her, whatever else she does is wrong. In fairness to her, she hasn't, and as you're going to discussing the presentation, participate in that, describe that. You say to Spoe that it gets to participate, we get to express our views. So what we know and what we must on this is that at the latest, 19th January 25, you are involved. These matters, this project called diversion. And the ID at this point has not excluded.
Chair, I wouldn't describe it as being involved. I would say I'm aware now that there is, because remember that what happens, the email is sent and then there's going to be a meeting. My expectation is that that's when I'm going to get more details about and as to what are the issues.
Yeah, I suppose you and everybody else that didn't know anything that was in this presentation would find out this meeting, what it is about, which you do, and we will get there. At this point, I'm making the simple point that after taking the matter from wherever she got it, when we've had a long debate about how this matter lands the ID, but having taken that on the 19th of January, but in fact earlier than that, when she gives an instruction that you should be invited, the presentation should be prepared and you should be invited, and then it's at the 19th of January, you are part of it. However it plays out later. We are not yet at how it plays out. We are at, this tells us she hadn't excluded. So you do receive the presentation. You do look at it. In prep of that meeting, you look at it. If you didn't, it's a choice that you made, but it's given to look at. So you do get to become familiar with what's supposed to be discussed come the 20th. That's correct.
Then before we get into the presentation, I just want to note one thing. In that affidavit from Ms. Rams, she notes that on the 16th, Johnson had asked for your said there'll be a meeting and all of those who are designated be there as well as yourself. You recall that? That's what we read. Recall that?
No, I don't recall that. I'm not sure. Are you saying that I was part of that conversation?
No, I'm not saying you're part of the conversation. I'm saying that, do you recall when we read that paragraph, that what Ms. Ramsamy was explaining on the 16th, Advocate Johnson was asking for your inclusion into this meeting where this operation would be discussed.
Yes, sir.
Now you'll note, just want you to note that this presentation was initially prepared by Chief Paramore, and when Chief Paramore sends that presentation, he's the one who excludes, and it's Advocate Ramsamy who then sends it to including yourself and Ms. Johnson. It's one of your investigations.
Okay.
Now, and I just want us to note that for now.
Okay.
Now let's go into the actual presentation. This is still in file 10. It's then basically 2 pages down at page 218. You'll see there's an introduction that deals with crime intelligence. My apologies, it starts with the cover page says Operation Diversion. The introduction deals with crime intelligence and that they're plagued with corruption and allegations which threaten, they say, the country's national security. So it's all there in that. But what I want to draw your attention to is the background section. And in that section, you'll see that they detail the affidavit that was received in terms of Section 27. And then it notes the allegations that IDAC was to initiate investigations into. It's a fictitious housebreaking incident. And then there's the procurement of a forklift using CI COVID fund. There is promotions or appointment, in brackets, gratification to specific senior managers. And it goes on about abuse of COVID funds and then mentions the purchase of PKTT and the use of the funds to pay for hotels. Now, you would be reading this and then learning about the nature of the things that IDAC investigate. And on the face of it, some of them don't appear to fall under IDAC's mandate. I'll draw an example to the procurement of a forklift, for example. That's point 2 of the allegation. When you're reading those, and you're seeing what appears to be things that on the face of it don't fall within the mandate, what goes through your mind?
Commissioners, my view at the time, the presentation is not normally a detail. So the meeting would give a detail. So I honestly did not raise eyebrows with it, with the understanding that when we get to understand what this is about.
But did you then get that detail?
Yes, as I had testified earlier, Chairperson, that when the team members explained what is alleged here, it was how it was presented was that there is corruption, manipulation of processes, there is issues of gratification. So those were things that were discussed that then said justified why the matter was in IDAC. But also for me, it was because the ID had authorized. I did not question much about what is being presented would be something that does not necessarily fall within the mandate.
But the issue was about the mandate itself, and as I understand it, the substance of the question by Ms. Bowe is whether all these indeed fell under the mandate, and that question cannot be answered purely by the ID having authorized what was going on. The question of the mandate is a legal question answerable in terms of the statutory mandate. So I'm not sure that what you say answers that part of Ms. Bowe's.
Chair, as I'm saying that at the time, based on what was presented, that's how I understood that what the team members were presenting to say what is alleged and what is then the offences would then fall the IDAC.
And Ms. Bowe specifically refers to the procurement of a forklift, and she suggests to you that that could not possibly have fallen under IPIC's mandate. You say all the questions were answered. Was that question or that issue answered? That specific issue?
My memory serves me well, Commissioners.
If so, how? Because unless, for example, you are able to say there's fraud, there's corruption, or there's corruption insofar as the procurement was concerned. If there wasn't corruption in relation to that procurement, then it would have been an offence falling under IDAC's mandate insofar as there is provision for certain specified statutory offences. But those, at least on our interpretation thus far, those should be additional related offences, and we interpret the additional related to be additional and related to the other offences specified as falling under IDAC. So Ms. Bowe is suggesting to you that the procurement of the forklift not possibly have fallen under IP's mandate.
Commissioners, as I remember what was presented at the time, the issue of the forklift, it was not one, what I remember. It was a number of, and this irregular procurement was alleged to have cost the SAPS. So
it's not the amount that would make an offence fall under IP's mandate. It's its nature in terms of what the Act provides for. It's not the magnitude of the amount involved.
Commissioners, my understanding,
or don't you agree?
My understanding at the time was that.
Don't you agree? Don't you agree to the proposition of just that? It's not just the magnitude of the amount involved, because that's what you said in response to my last question.
Commissioners, how I understood is that it falls within the mandate in the context of financial offence as provided for in the Act, and also the fact that the amounts involved. So when I looked at it, or at from what presentation was made, I understood that, and I didn't question why it's not in our mandate. And there were debates about it, but ultimately it was settled that.
Am I mistaken? Why do I seem to recall that the mention has been of a forklift singular? You are talking about many forklifts. I'm not aware that that's the evidence. Everybody has been talking about forklift singular.
Yeah.
Even the presentation indicates it's a forklift.
Yes.
And even what's on evidence was it's a forklift, and it cost it was about 200 and something thousand.
Have a look at page 3.2, the very first bullet on that page, the procurement of a forklift, and indeed that accords with my recollection of the evidence throughout this IDAC stream of testimony. So you say a huge amount was involved because there were several forklifts. So your point about several forklifts and therefore a huge amount of money falls away is just one forklift.
I see what is in the presentation as well.
Yeah.
I'm talking about what was as I recall in the meeting.
But how can that be? How can it be that when the testimony of everybody, including Advocate Johnson, your other colleagues, everybody has been talking about one forklift? How could they at the presentation have spoken about many forklifts? I'm inclined not to believe that there ever was such a in Sesoko.
Chair, I may be mistaken, but that's how I recall.
If you are wrong, would there be a basis for having thought that this fell under IDAC's mandate?
No.
Thank you, Chair. I recall that when Commissioner Khumalo asked the Advocate Johnson what does procurement of a forklift that wasn't delivered with IDAC's mandate, she too couldn't. Now, while we're dealing with this meeting, let's leave aside aspects of 27 referral. one of the major things that happens in this meeting is, and you note that also in your affidavit, is the issue around report comes up. And in particular, the ID indicates that she would do so through the Office of the Staff. Is that correct?
That's correct.
And when that happens, you then indicate to her that it's not a good idea because Mr. Ngabinde is not a compromise. Right. And then the ID asks for information related to this, and then
correct.
you agree that you would provide this.
That is correct.
What did you understand that she would do with this once obtained?
That she would alert the minister and the advisor.
And to your knowledge, was that the only thing that was intended?
Well, at the time, that was what was said. But subsequently, when I provided her with, then she instructed that senior investigator Bridgette should look at
And on what basis would senior investigator Bridgette to those matters?
Chair, I assumed that because they have been raised, and the documentation that I've shown her or given to her that come from the analysts show that there is that collusion. I must hasten to say, as I've indicated in my statement, that this is a matter, what I refer to as the blue lights, and as I understood before I even went to IDAC, that there was a consideration charge in Ngabinde related to that matter on what was discovered. However, the DDPP responsible for that matter at the time took a view that they shouldn't include that, because as I understood, there was an addition to the accused before, and there was a fear that when they add further accused, they might face a 342A application by the defense. They didn't want the matter to be removed from, and the view that was at the time was that the matter will be dealt with later outside of blue lights.
In the normal course, IDAC PA, they account Minister of Justice. Did you not find it odd that the ID is reporting back Minister of Relation to ongoing investigation, where the Minister of is not there? Because by the time you went to, you must have known that the Adams. Did you not find it odd that you are now asking the ID report to Minister of on matter of nothing? And is that not interference IDAC?
Well, Commissioners, it would seem like that. However, at the time, because I think she would have mentioned that there was a letter, then I think it was the context why she had to report. That's how I understood it.
Assuming there was a letter from, do you not find it odd that the IDAC reporting is on when he's not the complainant? So why does IDAC report on ongoing?
Commissioners, in retrospect, I realized that maybe I should have raised that, but I did not raise it, and maybe not have been.
You assist. It's not a question of just you not. It's a question of you saying, actually, let me get you dead on Nkabinde, show the minister that he's not the reporting through.
My view, Commissioners, at the time was that based on the hit that I know of Nkabinde, I was worried about that communication that goes to Nkabinde. So that is how I look at it.
My issue is that your worry is placed. Your worry why are we minister of ongoing IDAC? Forget who his secretary or who's of staff. Should not be reporting stuff on ongoing investigation where he's not complaining. Complainant is the other.
I take the point.
What you did, you opened a line of relation, which you later complain about, and you subsequently lent a 41 or a 30 member, which has been authorized relation.
I'm not sure I understand.
The investigation to find out what case involved and that report attached, you came up with because you said you don't trust me, it's honest. The ID then said find information. You then did to her.
That is correct.
And as a result of that, somebody told Nkabinde, we don't know who, that IDAC is investigating him.
That is
the
correct.
domino effect of that is that the 41 to one of your colleagues was then authorized and lawful.
That is correct.
Yes. So you set it in motion.
Yes, in a way, it appears like.
Yeah, may I just also raise my concern about this, that you became complicit to an investigation into Nkabinde. There is now because you said what you did, but you participate in that investigation because you go and find information on something that you volunteered. You're the one that volunteers, and then there's an investigation. But that investigation is not founded on anything in the act. The investigation, there's no complaint, there's nothing. But you're all happy to investigate Mr. Nkabinde on the back of what you have said. You don't have a problem with that. You're the second in charge. You don't say, hang on, I was just sharing purposes of communication, because if that's all you were doing as the one who holds the rules and who should be holding your people, your investigator, to your manual and to your rules, you in fact become complicit in an investigation into Mr. Nkabinde. And from where I'm sitting, it's no different from what Mr. Perumal has been doing, which is conducting investigations or participating in investigations that do not comply with your manual, that actually do not have a basis in your act. Because this which you are now investigating about Mr. Nkabinde, it doesn't arise from the act. It doesn't. And in that way, you put yourself in a position where you are no better than what, in fact, Ms. Johnson does on this. You're just as liable, or should be just as liable on this. If it's a point of criticism that an investigation was conducted on Mr. Nkabinde, it applies only to you. Do you want to comment?
Yes, Commissioner. As I said earlier, that the issue of Mr. Nkabinde was part of the blue lights. Now, at the time, as I've indicated, that the DPP that was responsible for matter had parked that. Now, the ID, when she instructed Mr. Bridgette that she must look into the matter, in my own understanding, would have been the extension of that on the blue lights. But as it turned out, because of what happened in relation to the allegations of the leak, my understanding is that even that issue was never taken.
It can't be that you believed that it is an extension of that investigation. The DDPP has taken a position how he's going to handle that matter. This investigation arises on your words, and I think Ms. Ramsame's words. It is the ID says, find me dead on this person. It's not. It's in fact an investigation for ulterior purposes, not for the original of the blue lie. It has nothing to do with that. It has to do with he gave the minister the ID EBGBs. I can't think of another word. Sorry, Ms. Ramsame said that's what the ID said. I don't like this guy. He gave me the heebie-jeebies, and then you say, oh, don't actually send stuff to him because I don't trust him. And then she says, find me stuff about him. So that has nothing to do with your blue lights investigation, and you must accept it is because the ID is looking for something on him that will enable, according to her, warn the minister that you do not trust him. So I'm sorry, the answer is not. Your explanation now that, well, it was a resuscitation, it's not. That's not what can we accept that?
Commissioner, I would concede based on what you are saying to me now. But at the time, that's how I honestly looked at it.
Maybe let me ask you a last question. At this point, what was the nature of your relationship with the ID that hopefully provides an explanation of your posture when she's doing clearly things that are wrong? Because it is wrong, this investigation. And that's not me saying there was no merit in the blue light thing that you've decided to park against him. I'm talking about here what I say the motive had nothing to do with the blue lights, had with how she claims he made her feel, but also now she wants to warn the minister. For you not to say to the ID, no, that's wrong. Thank you.
And then just on the last thing on this point, I just want us to go back to Ms. Ramsame's affidavit at page 252, at paragraph 2.27, 6.20. You will see there that Ms. Ramsame gives a recollection of all the things that transpired and who then was assigned to do what in relation to this Nkabinde matter. You'll see she starts by saying that began explaining the IP history of Nkabinde and all the events leading to Nkabinde's resignation. Said Mr. Sesoko further indicated there was a case where transcripts were available from Nkabinde's time in IPID and asked Rapesu about this and to share it with all of us. He also asked Rapesu about a case, cannot recall the exact acronym KMP or K. Rapesu then replied that he would send same. And these are matters that were during your time at IPID, is that correct?
Yes, that's correct.
And it seems unrelated to the blue lights?
Yes.
All right. So those are the first set of documents you were going to provide to the Advocate Johnson?
No, the documents that I was going to provide was what came from the data analyst.
Yes, that comes up later. So this
Yes.
one, you had asked Rapesu about this and that he must share those transcripts.
Yes, that was in relation to the KJP matter where there was a credibility finding in Nkabinde.
Yes. So what I want to show you is that it was not only that Mr. White report, there was more that was shared about Mr. Nkabinde. So that's the first transcript. And do you recall anything about the KMP or KG matter?
KG.
That too was was to be shared.
Yeah, that relates to the transcript.
Okay. Then it says that further discussion ensued by Sesoko, including the fact that there is currently a case in called Blue Lights where Chabal is a cuter and Binang is the IO, and there were links to Nkabinde. So this one is the one that...
Yes, that's the one I was referring to.
And so that's the one with the analysts was supposed to provide the report, and that you provided. Now, if we move on this affidavit, you'll see that at paragraph 0.9, Ms. Ramsamy explains that on the same day, Sesoko contacted me telephonically indicating that he was on his way to the office and wanted to see me. When I went to his office, I found Binang and Chabalala. The discussion was about White's report. Chabalala indicated a standalone problem case can ensue and Binang can start finalizing the investigation. Sesoko indicated that he did not want any of the IPID investigators to deal with this matter and that a neutral IDAC investigator do the investigation. So if you consider the deliberation that you just had with commissioners, it's clear that you were steeped into this investigation.
Yes,
and you were having meetings to see how you can further.
Yes, for me was the issue of furthering what had been parked in relation.
But you are not furthering it because it was parked in the Blue Lights matter. If that was the case, then it would have emanated from discussion with the team, with the investor Binang, Chabalala, whoever would have in that. If this flows directly from your meeting with the ID, where you had a great suspicion about.
Yes, it's true. It flowed from.
Yes, so you're not furthering that, and this is a completely that stems from the ID's office.
I did not look at it that way. I looked at it as taking further that Blue Lights.
I want to make reference to one more thing. If we can go to page 245 of file 10.
245.
You'll see there it's WhatsApp exchanges. My apologies, 243. We can just go up. you'll see those are WhatsApp exchanges between Ms. Ramsamy and Advocate Johnson. And there you'll see that before that, there is communication about the prosecutions that were ongoing. And then there is talk about the white report, which you assisted in obtaining. And then if you go down, you'll see that she then says to Ms. Johnson, can Mr. Sesoko and I brief you in detail when you are available today or Monday to give you a full picture? There is more than what we actually thought, and get direction, because he was supposed to charge on these things in 2019. Now, when you consider the chronology of what happens from when Mr. Nkabinde's name came up in that meeting, what it seems like happened is that Ms. Johnson referred to Mr. Nkabinde. You may have at the beginning innocently indicated your concerns around Mr. Nkabinde, but what follows was an investigation, a full-blown investigation, and using investigations that were ongoing or matters that were ongoing in IDAC in order to Nkabinde.
Chair, I consider that there were these discussions. And as that WhatsApp message shows, remember, these issues were already part of that blue light. So the report was already there. So it was not like there was new thing that was to be started in terms of investigating, at least based on the report that was already there on the blue light.
Ms. Boyce.
Let's go to 6.40, where Ms. Ramsamy says, proceeded to explain to the ID and Paramount the links as per
6.40.
No, Commissioners, I was told that the witness's file broke, and so this is why it takes slightly longer to get things sorted.
Yes, I'm there.
It says, Sesoko proceeded to explain to the ID and Paramount the links as per the chats provided by White. There were discussions about the investigation that would proceed. Paramount indicated that Belachan can continue with the investigation. Sesoko stated the sentiments he shared in the meeting as per paragraph 6.39. The ID agreed and stated that Parayachi would then attend to the investigation. You see that? Now,
I see that.
Your involvement continues after as well. We look at what happens at paragraph 6.44. On 30th January 2025, Sesoko contacted me regarding the authorization documents for the Nkabinde matter. I sent the ID a WhatsApp asking if that authorization should be done in terms of which form of authorization. ID advised me that she will check and further advise that something terrible has happened and I was not to discuss the matter with Rapesu or Sesoko. I advised her that my discussions on the matter were limited to herself, Perimo, and Soko, but would cease communication until I had spoken to her personally. Now, what you'll note there is there's a communication there about authorization and how those would be done. Now, if this was an extension of an ongoing investigation, wouldn't it be simply an authorization in terms of that existing authorization?
Yes, that's what it's supposed to be, and that's how at least I understood the time. But I see that she was asking about authorization.
In fact, he's saying you were asking about the authorization document on the matter. So it couldn't have been an extension of those existing matters.
I cannot recall asking for authorization. I don't think I would have asked for authorization when I knew that the blue lights matter.
Thank you. And then I just want to put one more thing to go back to your statement. And my apologies, not even your statement, annexure MS7, which is an email that Mr. Nkabinde sends to the investigator, Mr. Mbalo. And this is when he was being asked to use a affidavit. And this is then his response to Advocate Johnson. In particular, if we can have a look at paragraph 4. And it says, what I was told was not a surprise to me because I knew it was based on jealousy and hatred by Sesoko and his team, who were my former colleagues in IPID. And because of our past, which was on the public domain, I knew that if indeed they had any genuine complaints about me, they would not wait for 7 years because I know I am the number one enemy. So now because I got a decent job, plots of such nature are starting. When I called Advocate Johnson, I was alerting her of a plot against me not to lay a complaint. If I intended to lay a complaint, I was going to do so formally in writing. Now, I just wanted to get your comment to that. In my mind, it's either that this whole investigation was furthering this, Commissioner Baloyi, because of the heavy moment, I now want to say this BGB-related matters.
I couldn't think of a better way.
the discomfort that Advocate Johnson had, and now there's a campaign to deal with Nkabinde. Alternative, could it be what Nkabinde says about your relation? So I just wanted to respond. He says he thinks the campaign is because of your history.
Commissioners, it's true that we have history with Nkabinde, and I'm the one who removed him from an investigating team after we had found that he was colluding with suspects in our. So it's understandable that from his point of view, he thinks that I had an agenda or I wanted to get back at some reason. But I never had that kind of an agenda. For me, it has always been that because of what I knew and his involvement in criminality, he had to be held up. That is all what was in my mind at all.
Then I want to deal with another as emerged from this meeting, and this is a tasking that was given to you in relation to the I do that. Maybe to show you where that emanates from, if we can go to, we'll display it because I don't recall asking that file 11 be brought, but we'll just, and then it's also in the supplementary statement at paragraph 6, Ms. Ramsamy is supplement. I'll just read from the supplementary 9 of her supplementary statement. She says, after she set out the various investigations, Advocate Advocate Johnson said that we are to investigate corruption, PFMA violations, and the Secret Service account. Mr. Sesoko was tasked with arranging a meeting with the IGI, which did occur. And now this is in relation now to Project Diverge, is it not?
Yes, it was. If I remember well, they needed some documents from IGI, so I was asked to arrange it.
And I think what I want to say with this is that it's to your involvement. So it's not that you're there passively, it's that you are now being involved in this matter. You see that?
I see.
What documents were requested, or do you recall?
From my recollection was that the IGI would have conducted some investigation, and they needed some. So that meeting was about that. But the IGI indicated that.
Excuse me, the IGI didn't provide it.
They cannot provide that.
And was it only related to that? Because if I recall correctly, Ms. Ramsay was part of it. Was it only about the document?
That's how I recall it.
Now, the next aspect I wanted to deal with, if we can go back to your think I'm done with the meeting. One aspect I wanted to ask you about in relation to the investigation to this, or Mr. Nkabinde's alleged complaint, rather Advocate Johnson's. Now, what develops, this is what you testified to earlier, is that it then became clear that it was not only Mr. Rapesu that was, it was yourself and Ms. Binang who were being.
That is correct.
For what was this being done? I can only imagine the thought about this. You may know a reason why this, particularly given the fact that you are the person who raised complaints and obtained these documents that were dealing with Nkabinde. So it seems bizarre that at the same. So why do you think this whole was being done against you yourself?
Well, I do not really understand why the investigator would insinuate my involvement, because he says he received information that I revealed something enough. But in retrospect, I'm thinking that it must have to do with the fact that there was a conflict between the Perumal and Mr. Rapesu, and therefore they just wanted to get everyone that is formally from IP. That's how I thought it could have been the reason. But I'm just.
Thank you. Now, I want to deal with another aspect related to your involvement with this project Operation Diverge. If we can go to the set of screenshots that were provided by Ms. Ramsay. Now, I don't propose we go through all of them because there are many. Commissioners, they would have been inserted to your files. File 10 would be at the end of file 10.
Oh, 10.
Yes, it is 400. Commissioner, could they not? Yes. I think the one that was inserted into your files has pagination.
You said we go to page 4 what?
405.
40. And my file is also about to.
Maybe it's a sign mistake.
Yes.
You'll see there that after the meeting of the first email is the one sent on the 9th, but you'll see thereafter that, at least from Ms. Ramsami's point of view, she starts copying in the emails related to Project Diverge. You see that? So the next one on page 406 is related to the housebreaking that would have Shaba issued.
Yes.
Maybe a correction is forward. It's not a con address. As I said, it's not copy, it's one of the address.
Yes, you are. This one is addressed, and it was in particular in relation to statements and diary entries made by Mr. Rape. If you go to the next page, you'll see that this was also addressed to you and Ms. Johnson, and this is in respect of the prosecutor's instruction not be taken as disrespect by the investigators. And there, you as the head of investigations are also, you get.
That's correct.
And I'm assuming she expects that you deal with it because Chief Perumal is a subordinate of yours. See that? Now, if you go on, you'll see that the next one is in relation to a report. And if I'm not mistaken, this is again the Lushaba matter. If you continue, you'll see an email.
Looking for now transcript.
At page 4, my apologies, page 407 is the one in relation to Ms. Ramsami's complaints about her instructions regarded as disrespect by the investigator. At page 408 is a report that comes from Mr. Rapesu, and there you were copied. And this, as I understand, was in relation to the Lushaba matter, where he had done a report. Then at page 409, you were also copied in an email, Advocate Johnson, related to the SAPS Tembisa hospital tender. And then at page 410, that one I want to deal with because you'll see in the subject matter it says diversion arrest, and this is addressed from Advocate Johnson, where the commissioners will get the full emails because this is cut. Here, Advocate Johnson.
Maybe the date on record.
Yes, this is on the 4th of June 2025 at 9:24 a.m. Advocate Johnson says to Sesoko, I asked Dylan to let me know when they will arrest, as I need to inform the. He indicated that the main accused is on, etc., and they might push for this afternoon. I let him know that I don't agree. I cannot tell the ND today that we are arresting today. What will our urgency be based on? In addition, the DPP is not a rubber stamp and should be given an opportunity to paper. I suggest we wait for weeks when the main accused back at work and then proceed. I'm also aware that accused 4 is not in Gauteng. The team has next 2 weeks to determine exactly where all the accused are. When we do arrest, we should be able to pick them all up at one go. Now, again, this doesn't look like it's sent to someone who is not in the know. This looks like it's sent to someone who is part of what's being done.
It is correct that it looks like that way.
So, and can this take it as a fact that you were then involved?
Commissioners, these discussions did happen, and as you will see that I'm in the email.
Please, can you please answer the question directly? Is it so that you were involved?
Yeah, I would concede that I was involved.
Thank you.
So your earlier answer that we came away after the arrest, that was because email says the arrest has to happen and they are being planned.
Yes, I did not say I only became aware after the arrest. I said the takedown.
Isn't that the same?
No, because there's a planning on the takedown. But yes, I see from the email that I was made aware that there's an intention to arrest.
Then, having accepted your involvement, I then think a lot of the correspondence makes sense because we know that, for example, when there was an issue with the 67, Advocate Runye sends a message to you as well, saying there's this issue of the 67. Similarly, Advocate Ramsamy also sends a long explanation about the section, and there too you are just going to go, think you were copied, and that's at 4.0 of file 10. See, the email was sent on the 9th of October 2025, and it says section 27 referral if Adam in the subject line.
Yes.
And you'll see that she does a long explanation about her account of what happened with the section 27 referral. And in particular, I want to draw your attention to 1.4, where she says, on the 10th of June 2025 in your office where a meeting was held with myself, Mr. Sesoko, Mr. Perimo, Mr. Padiachi, Mr. Mlambo, and Mr. Charles, I entered that we needed the documents in the folder. At that point, we were all packing proof of. You indicated I should text the following day and that you would look for it through the mini box. And this was this for the arrest happens around the time they were planning under Operation Diversion.
Yeah, I think it would have been. I think it would have.
Again, it just speaks to involvement. I think now that we know that you were involved, we've passed this, and there's one other aspect.
112.
We can then just continue with those. There's then another email that is sent by Mr. Rapesu in relation, this is at page 411, in relation to the chain of fiction for the dockets that you assisted. And then at page 412, you'll see that this is an email that's sent, from me. And there you had done a project diversion media status stand. Do you recall that?
No, I cannot recall that.
We'll obtain that email as well as the annex. And then at page 41, you'll see you were copied on an email in relation to the charge sheet in the Lushaba matter.
Yes.
And this was an email that was sent to General in June 2025, on the June 2025. Then at page 414, you'll see that is a calendar invite for a meeting on project diversion, and you were one of the participants. At 415, my apologies, let me just the date on record, this 24 July at 7:05 a.m. At page 415, you were copied on an email regarding leg 1, project diversion, which was the Lushaba matter, and this email was on 16 October 2025. At 416, there was a meeting request for further particulars in one of the cases. Again, here I'm not sure if you were but you were part of that email chain, and that was on 22 October 25. At page 417, you'll see that was an email with the subject line diversion case 1 in Lushaba and Khumalo matters, and there you were copied on an email dated January 27, 2026. And then on page 418, this is a 28 affidavit. This is in leg 1 diversion. Leg 1 was the Lushaba matter, and the email was on the 8th of January 2026. This is not the sum total. I had just requested Ramsamy to provide the correspondence shared amongst including yourself on these matters since the meeting of the 2nd of January.
From all this, it appears that you were involved throughout.
That is correct.
Some emails were sent to you directly. On others, you were copied. And besides just emails being sent to you, some of these say there were requests for meetings. You yourself have said that you did attend the meetings.
That is correct.
And then also, and crucially, you have also accepted that you would attend to what I may loosely call logistical matters. You personally pursue those, make requests to, let me say, people outside of IDAC, make requests, get information that was required for purposes of this litigation. So all of that paints a picture of you being fully involved. You accept that?
I accept it.
Yes, yes, Ms. Bowen.
And then one other thing I want to quickly touch on is if we go to file 11, I know you don't have it, so I'm going to ask you to get your screens. And you will recall that these are notes from Ms. Ramsamy where she was telling us about one of the contents of a meeting which happened on the same meeting on the 22nd of January. And in that meeting, one of the things that was discussed was essentially a plan, and this was something that Advocate Johnson said, a plan to catch out the National Commission. And the idea was that they wouldn't tell the National Commission about investigation, would then be summoned to Parliament to account, and then he would lie and then caught out. And this plan was discussed at this very meeting. I don't know if you recall that plan.
I don't recall any discussion about such a plan.
You were in the...
I'm not sure which which date.
22 January.
It's the meeting on the 22 January, yes, where the presentation was made.
I honestly don't recall that discussion about the setting up of the NASCO.
And you'll see it happens just before there's a discussion about that IGI meeting that you were to facilitate.
I see.
So got sufficient grave importance that you were at that meeting. I would expect you. I don't think it's every day unless you are telling us that you sat in meetings where every day this talk about setting up the national came up. Then I would understand, well, it's one of many meetings and we can't pin you down to 22nd of January. If it's a once-off discussion, efficient seriousness, that I don't understand that you don't remember. You were in that meeting and you've told us you participated. You can comment.
Commissioners, I understand where the commissioner is coming from, but I honestly don't remember.
And if you read those blocks, you'll see that the IGI was to give an intelligence file. You see that?
Yes, I can see that.
Yeah. If you don't recall, I can't any further.
Perhaps more accurately, if you say you don't recall,
Yes, if you.
then there's an important nuance there. Yes, Mr. Sesoko.
No, I was talking about the NASCOM one, the IGI one. I get that, yes, there was a...
Yes, Ms. Bowen.
The one last issue that I'll canvass, two issues that I'll canvass with you relatively short. Now, when you testified earlier, you told us that there were two experiences that have shaped how approach these matters. And you mentioned after your testimony at the Zondo Commission and secondly your kidnapping. Now, the kidnapping happened after a lot of this has. So I'll focus on the victimization that you want to regard to victimization that had at IDAC. Now, was your view that you were to say something about what was at IDAC victimized? And if the answer is yes, by who?
Commissioners, how I viewed this whole matter at the time was that based on my experience and what I went through, sometimes standing up to things that are wrong, you end up being a victim yourself. And I know that may not be satisfactory, but at that time, I took a view that when the ID takes a particular decision, I fall in with it. And that's what I did.
The problem with that is if you want to be a leader, which you are, you should not put up your hand to be appointed as a leader. If that's your attitude, you just should not put up your hand to be a leader. In fact, standing up to authority may even be expected of officials who are by far junior to you. So with you, it's worse.
And I accept that.
Chair, the last aspect that I want to canvass is in relation an incident that happened around the 24th of July, 20. I just want to say, the reason why I make mistakes with numbers is I have numeric dyslexia. So I see something, but I read else. So this is 24th July, 20. And this was after staff and Ms. Ramsamy wasn't there and who then spoke to Ms. Ramsamy. Recall that. In particular, she was wondering what she had done. Recall that. In particular, she was asking you what she had done to advocate and Gator Paramount. Recall that.
I had a lot of conversations with Ms. Ramsamy. Maybe you can remind me.
Don't you want to be more direct?
I can be more direct.
It is.
Yeah. Ms. Ramsamy, because she's not done with her testimony, I'll say she will testify that during that conversation, when she asked what she had done to Advocate Johnson, your response was that her problem started when Ms. Ramsamy was disagreeing with Chief Paramore and that Johnson Paramore. Is that the situation that was at the office? And that was a known situation.
Yes.
Which means that Chief Paramore had an immense power because in there you to her that Advocate Johnson lived Paramore.
Yes.
Now, in that conversation, she will testify that you also told her that Chief Paramore approached after a meeting and told you to speak to her, Advocate Ramsamy and Mr. Rapesu, so that the situation can be fixed, because if it isn't, they, being Mr. Paramore, would be arrested and charged. Do you recall that Mr. Paramore would be charged? Do you recall that?
Yes, there was that conversation. And yes, Chief Paramore did approach me and to say I must talk to them. And that I don't think that he would have said charged in trouble. That's how I remember.
And who were the they that would be charged? Was it Chief Paramore?
Or would be in trouble according to the
Yes, he was referring to.
And do you know why they would have been in trouble?
Well, I think at the time it was clear that the issues of how they dealt with the matter would come up. So, because in that meeting, there was a file that Rapesu had. And then in that file, it would appear that they had inserted some information which was not part of the file. And Rapesu indicated that those documents, which, if I recall, were related to the Falkland, were not part of that file, and they would have inserted that file. And fortunately, he had done a record of everything that is supposed to be in that file, and those documents were not part of it.
And this would have also been after or in the midst of Johnson's before this.
Yes.
And so Mr. Paramore had approached you so that you to those because they were the ones about what they were.
Yes.
Chair, I don't have it.
Thank you, Ms. Bowe. No re-examination, Mr. Ramatsik.
None.
Thank you. Mr. Sesoko, after a long day, you are but should issues arise that require that you be recalled, that may happen. And you have heard Ms. Bowe say that Ms. Ramasamy is going to say something that relates to you or is about you. So you are excused for now, but I'm just saying we don't know now. But you're
that will be knowledge.
We are not sitting. I had prior and before there was the hearing of evidence, and then the 31st of July, get out of. So we are not tomorrow, and on Monday, public. So we are generally at 9:30 on.
Women's Day.
At least you cannot accuse me of not being cognizant. Go to the opinion piece on the Daily Dispatch of today. You'll see that I'm very much cognizant. Let's adjourn until then.